Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
That's weird. Okay. Back to one. I don't know. That was weird. Okay. I'm back. I will start again. Good morning, everyone. Today's Friday the 13th, Friday, February 13th, 2026. And today we go back to day 9 of To Kill a Mockingbird, aka Georgia versus Edrick Faust in Athens-Clarke County, Georgia. As a side note, I watched the Stefan Diggs arraignment a few moments ago in Dedham District Court, Massachusetts, and I was the only one on the Zoom besides the court. It was crazy. It was 3 minutes long. I'm not even sure if Stefan Diggs was in the courtroom because the only person that I could see was his attorney, and so he pled not guilty. And the next pretrial hearing on Stefan Diggs is going to be April 1st. 2026 in Dedham District Court. It was 3 minutes long and it was wild to me that nobody was there. If you have no sound, you are behind. Thank you so much for coming, but you are behind. So when you get up to real time, it's an Atlanta Braves hat. We're in Georgia, you know? All right. Interesting. So that was the interesting about the Stefan Diggs hearing. Today, we have to pull our affirmation for a badass. Today, I guess these are the cards. I guess I took them out yesterday. Okay, here we go. It is Friday the 13th. Here you go. Oh, he was in the courtroom? They had it on TV? Who broadcast it, Cheryl? Because I tried to look for a live stream and I couldn't find it. Maybe we can watch that later when we have a break. Start where you are, use what you have, do what you can. That is today's badass affirmation. Start where you are, use what you have, do what you can. Good morning. We have 4 cupcakes in court today. And we hopefully will be getting some reports. Nobody's allowed to use their phone in the courtroom, so we'll see what happens. The defense is supposed to start its case today, and we will see if they choose to put on a case. But already, Lisa Lott has taken the bench just a few moments ago. She's already on my nerve. Channel 5 in Boston. Thank you, Mitchell. I couldn't believe nobody was on the Zoom. All right, let's go into court. YouTube is making a lot of changes, as we discussed the other day. Who's Stephon Diggs? He's a Patriots player. He's also the father of Cardi B's latest child. Plays for the Patriots. He was just in the Super Bowl. He allegedly assaulted a personal chef who worked in his house. That is what the charges are about. The story is apparently she tried to get some money from him, and he refused to pay her, and so she filed criminal charges against him in Massachusetts. I am not muted. You are behind. Okay. If you see ads on your stream, YouTube is making changes. They are making lots of changes. They want to make money. Not my fault. I can recommend to you that if you get YouTube Premium, you will see no ads. I don't make any money from YouTube Premium. I am not promoting them. I have had YouTube Premium for years. I would never go back. YouTube Premium Lite is something like maybe $5.99 a month. If you are a person who watches live trials and you watch YouTube all day long, it may be a good option for you. Okay? Mr. Cruz is in court today. Here we go. Good morning, Lisa Lott. Let's see who, if anyone, she calls out today. Okay, there you go. I don't see that Fox 5 Atlanta has a stream up yet on YouTube, but if the audio sucks here on Law and Crime, we'll do the best we can to pivot around. Thank you.
Cruz, the court did not hear from you or anyone on your team yesterday.
And here we go.
Few matters that need to be handled before we get started. Mr. Cruz, the court did not hear from you or anyone on your team yesterday, and you had said you were going to keep us posted. I sent out an email not only talking about court, but also needing the information for your WebEx witnesses, and we heard nothing, which was a bit unusual. Right. I just assumed Mr. Hill would respond since he's a.
For those of you who don't remember, Mr. Cruz's wife was rushed to the hospital on Tuesday, and that is why there were on Wednesday, and he said it in open court, and so that's why there was no court yesterday. And he said, "Last thing I heard from you was just to be here at 9 a.m., and that's why I'm here." You can't hear him because he does not have his lav mic on, and I will repeat to you what he just said so that you don't get blown out, and so that until he puts his lav mic on, because he has been carrying a mic around with him. I'm going to listen to what he said again.
Usual.
So I didn't see any email, Your Honor. I'm sorry. My wife was in the hospital.
So I came and heard the hiss. I saw the last message I saw from the court was that they would be in court.
Last email I saw from the court was just to be here at 9 a.m.
Right.
That was sent yesterday. But please charge it from my mind and not my heart. It's the last one I was with my wife in the hospital. So just please read.
But please realize the last thing I heard from you just was to be here at 9 o'clock, and my wife was in the hospital.
I just assumed Mr. Hill would respond since he's attorney of record also, and I don't even see him this morning, but I put him on the email too, so I thought he would communicate with the court.
I can't speak to Mr. Hill, but I know I didn't provide him with the update, so I take responsibility for that as well.
He says, I can't speak for Mr. Hill, and I didn't provide any updates to him, so I cannot speak for him. Could you please, something like, forgive me? Remember how we spoke yesterday about how judges are supposed to even avoid the appearance of impropriety, even avoid the appearance of impropriety. And that was in a motion to recuse that we read on Kelsey Fitzsimmons. She's acting very cold. We don't know what is wrong. We don't know why Mrs. Cruz was rushed to the hospital, and it's none of her flippin' business. And yet she feels the need to publicly berate him on international television.
Okay. All right. Thank you. All right. Are you ready to proceed, Mr. Cruz?
I'll let you take and see where I witness it.
Well, we got to get into some issues before we do that. So, all right. So the
Hold on, I got to hear what he said.
Provided the update, so I take responsibility for that as well.
okay. All right. Thank you. All right. Are you ready to proceed, Mr. Cruz?
I'll let you take and see where I witness it.
Well, we got to get into some
He said, I'd like to check and see if our witnesses are outside in the hall.
issues before we do that. So, all right. So the first few things are this. This gentleman sitting right here, I need to know, is this this young man an attorney? Okay. Okay.
There were two new people sitting at the defense table. One is a man who was there, I think, yesterday, and another is a female. And he said, no, this is my law clerk and this is my paralegal.
Okay. Well, I understand that, but they are not allowed at the table during trial. So you're going to have to sit back on the benches. The other issue that I want to discuss, you both are going to have to sit on the benches. It is not allowed to have non-attorneys who haven't entered an appearance be at the trial counsel table. No, sir. They need to be back. The other thing is that one of the issues that I wanted to raise to make sure we're all on the same page, and this gentleman right here, I don't know your name, sir. I'm sorry. What's your last name? Evans? All right. Mr. Evans and Mr. Cruz, I know that you needed some information from Charlene Satterfield, who is our court reporter. You asked her when we were on a break, both of you at different times, for information for her to play back things from the record. That's not appropriate. We are in trial. If you need something from the record, it has to go through the court. And I want both of you to understand that it's definitely not acceptable for a paralegal to make a request like that at all. But it's definitely not appropriate for an attorney to do that without going on the record, either making a motion, asking the court, things of that nature. All right. Thank you. All right. I have the jury coming in later. And so this is the time for us to take up some other matters. We've just gotten the state's charges. Mr. Cruz is sending the charges to Miss Ellis. So she's going to get those compiled. Counsel, what we typically do, and good morning, Mr. Hill. What we typically do, and counsel for the state knows this, but counsel for the defense needs to understand this, is we will send you all a copy of the combined charges in one big document online. You'll get that on your email. So hopefully it'll be easy for you to look at it. When we do our charge conference, we'll print the entire thing out. Everybody will have a copy. We go through from front to back. So for Mr. Cruz and Mr. Hill, on jury charges, I always include for the court's charges, the standard charges that every superior court uses in every criminal trial. And so all of the definitions, for example, for reasonable doubt, for just as an example, evidence, the burden on the state and things of that nature are always included. You certainly can include those in your charges. If you don't agree with how the court does its typical charges, we'll certainly consider whatever you present. But I just want you to know, if you want to bypass the typical charges that are involved in every criminal trial, you certainly can do so and focus on the charges that are in the indictment. So that's kind of our process. I don't know when we're going to get to that, but I want to make sure you all know that it's going to be a big document for you to look over, and we sort of go through it page by page. All right. Let me ask the state, are there any other issues the state needs to bring up? I want to talk to Mr. Cruz about his timeline in just a second.
Your Honor, we'll have a couple of different motions in limine that we would ask the court to consider this morning prior to witnesses taking the witness.
Okay.
Whenever you would like to do that.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know, but if you have any idea of where we're going, certainly.
I think we'll be done by noon. I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I can provide that to the honorable court now.
Okay. We're gonna get, it's one of the reasons why I have the jury coming in a little bit later this morning is we need to get that set up
Yes, ma'am.
because I didn't have that information yesterday. So if you can actually send that by email right now to Miss Ellis, we're going to get that to Miss Craig, who is in the other county. She's in Oconee County, helping to handle court out there, and we will get her to set it up.
And I need to call her. She's not local. I think I advised honorable court of that, so I need to call her just to let her know that.
When we're ready to roll. Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time. Well, I don't know if we should do that. Let me think. Let me ask you this, Mr. Cruz. Do you already know the order of those witnesses? Which one's going to go first?
I don't. I need to speak.
Okay. All right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's better for the WebEx, that we'll try to do it in the order that you're going to call them. So they're not both on the same WebEx at the same time.
Okay.
Yeah.
Wait till the motion in limines because that may
Okay.
change.
Sure. All right. Very good. Any motions you want to present, Mr. Yeoman-Chili?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all of the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Sadi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens-Clarke County Police Department. In part, he interviewed individual by the name of, Stephen Barden, who was a law student at the time. And he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens-Clarke County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Sadi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a methods of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor. And I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call. If I could have just a moment to consult with Mr. Bolden.
You can. But you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall. Is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton. Okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's earlier ruling and prevent that process from playing out in the exact same way again. And then it's a similar argument with Sergeant Tyndall, because I think that those two witnesses are similarly situated as it relates to the phone records and their inability to testify to foundation for admissibility of those records.
All right. Thank you. And you may have a moment, Mr. Bolden, and then I'll hear from you, Mr. Cruz.
Okay. Your Honor, Mr. Bolden will be making a motion in limine as well.
All right.
Morning, Your Honor.
Morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalamanchili was just discussing, this is specifically as it would relate to John Newton's testimony. One of the things that the state expects that the defense may try to elicit through its direct examination of Mr. Newton is the fact that he had a conversation on January the 25th of 2001 with an individual by the name of Jessica Gann. That's Gann. Miss Gann, I believe, well, what's in the report is that she called and spoke with then Detective Newton on that date, on the 25th of 2001, January the 25th of 2001, that she was at Mexicali Grill over on the east side near Kroger, and she heard some girls in the bathroom talking about law school. They appeared to be drunk. This was at about 9:30, and she thought one of them may have been Miss Baker. I think Mr. Cruz actually referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly, the analysis should end there, but even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point, we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point in the form of the testimony of Ms. Lonstein last week was that Ms. Baker was in the law school library until at least 9:46 when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
It's so funny because she's let detectives testify to all kinds of hearsay so far, right? Rules for thee, but not for me. Huh. So there's somebody that was interviewed. Her name's Jessica Gann, interviewed by Newton. Newton already testified, remember? Newton testified on day 4 of this trial about lots of things, including The pubic hair. Interesting. Okay, so you don't want your own investigator that you called on your case in chief to be able to testify about someone that he interviewed who said that she thinks she saw Tara Baker at the Mexicali Grill around 9:30 the evening before her murder, and that she seemed drunk and she was with other girls that seemed drunk. Okay, cool. Yeah, hearsay's only good when it's good for, it's only should be admitted when it helps your case. Okay, great. We don't want to get at the truth. We just want a conviction.
All right, thank you. Anything else?
No, Your Honor.
All right, Mr. Cruz, several motions on the table. Go ahead, sir.
We don't know anything about Mrs. Cruz. Even if you do know something about Mrs. Cruz, you don't need to talk about it. It's none of our business. We don't know anything other than Mr. Cruz is in court today. That's all we know. Okay.
The only two that I'll address is first I'll start with, and good morning.
Good morning.
Board. First I'll start with Stephen Barden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, but for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of her murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in opening, as we've maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Keshana Armstrong, we're offering the information about Ms. Gann, again, to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count in the indictment. One piece of evidence they have not shown, they haven't presented anything showing where Ms. Baker was the night before her death outside of the library. And in regards to the timepiece, I think that's more appropriate for cross-examination as opposed to a motion to limine. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies, even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days after. So if she wanted to give and I believe the state made this argument in regards to a particular witness. I can't remember the witness, but if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion to limine we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's the issue that the Honorable Court has already ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right, thank you, Mr. Cruz. I'll start with the phone records. The issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been if you had subpoenaed the proper people to bring them in. We could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records. I advised the honorable court at that hearing that Sprint, and I believe, I can't think of the other company, but the companies were out of business. They sent me emails stating that because the records were so old, they did not have a way to verify those records. The state explained to the honorable court that they would
Stipulate.
They would, I'm looking for the proper word, but I don't have it now. So I just say they would agree that for foundation purposes, the records are admissible. They said they would object on hearsay grounds, things of that nature. But our argument was that the records aren't hearsay because they are computer generated records as opposed to a statement by a person. Just to put that information on.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time.
Right.
So let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. That hearing did occur. At that time, we had been in for several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz. And it was the state's belief at that time that we were going to be in a position where Mr. Cruz was agreeing to stipulate as to the foundation for certain crime lab reports. And in exchange, the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether.
So we did stipulate, Your Honor, but now we're not going to stipulate. Didn't she yesterday, one of her reasons for denying the directed verdict motion was because this is a cold case. And she kind of sort of said, we have to give a lot more deference to evidence because it's been 25 years. And so this is one of the problems when it's cold case and things like that. Well, another problem with trying a cold case is that Sprint, who used to be a cellular phone provider, is no longer in business. So they cannot get a witness from Sprint to come in and testify because Sprint doesn't exist. And Yamala Manchili is now saying, well, we did agree. We did stipulate that if they would stipulate to allowing some records in, stipulation is a fancy word for agree. If they would agree to let the crime lab reports in so that we didn't have to call somebody from the crime lab just to authenticate the records, we would agree to the phone records. But now we don't want to agree to let the phone records in because he never provided us with proper notice. Are you kidding me? This is not how gentlemen lawyers behave. Common courtesies are often granted to defense counsel and vice versa. This guy is a piece of work, man. They know how weak their case is and they just don't. They're embarrassed. They don't want the world to see it. And they're going to make it so difficult for the defense to put on a case that it's mind blowing.
And also foundation for certain crime lab reports. And in exchange, the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulations. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Any
Were they refused, or did he just not respond to you? You're saying he refused to stipulate on things with you? Okay, that's different, but let's hear what Cruz has to say about it.
Anything further, Mr. Cruz, based on Mr. Yellowman-Shilley's comment?
No, ma'am, that's accurate.
Okay.
We refused.
Okay.
stipulation
Okay.
by Mr. Yellowman-Shilley. Correct.
All right. Thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment and the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yellowman-Shilley. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted. And that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the
It
hearsay?
goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
All right. Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403, we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem.
How about letting the jury decide what facts are relevant? That's not confusing the jury. That's giving the jury all of the information so that they can make a determination as the finders of fact in this murder trial.
I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago is that's a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence that that would in fact have been true.
That's not what he's saying.
And without that evidence, that testimony that you are
He's saying they did a shoddy investigation and there's all these things that they did not follow up on. He's not saying that if they investigated the tip about the Mexican restaurant, that the case would have been solved. Hello? Where's Cardi B? He's up and ready to argue.
seeking to elicit, certainly I would say falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order.
You know what's misleading the jury? All the gobbledygook that you let in about the, the detective saying that Faust's DNA was inside the house. And his gobbledygook about, Jeremy testifying, oh, yeah, well, his DNA was in the house. And Faust said, well, it was on her. Mr. Cruz said it was on her body. And he said it was in the house. And he said, yeah, but it was on her body. And he said, well, her body was inside the house. What do you think is confusing the jury more? some of the junk science about DNA that you let in, or an actual witness who actually went to the police at the time and says she thinks that she saw Tara Baker or overheard Tara Baker in a Mexican restaurant the night that she was murdered. Wow, man, wow.
That there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you know, you certainly can respond to what I've said, and then we're going to kind of move on. But go
We're
ahead.
just going to move
Two
on.
things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica again, this case would have been resolved. I believe I said it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Miss Baker. So that would be my response. I do not believe that one fact would confuse the jury, Your Honor, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, the Honorable Court has all the wisdom. I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, you know, we have this fact. Now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right. Thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what
This Jessica Gann person, she was a witness who was interviewed by the police in 2001, but now she's just this Jessica Gann person. And he was actually able to find her and subpoena her to come in and testify.
you're saying, Mr. Made, supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state? Let's do this right now about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records.
And that's what I was Can I
Okay.
respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
Via the court order he
Right.
obtained, via recognizing the phone records, via stating that
Right.
those phone
Right.
that they didn't appear to be altered. So he laid the foundation
Sure.
for the records that he received.
I remember that. I have that in my notes, but let's just get this out now so we're not having any, problems
I
later.
do not believe
She's helping the DA. She's giving him ideas. It's wild.
that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is to the
But the
content.
admissibility in the
The
content.
fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right. Thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but was Newton?
Yes, ma'am.
Yes, ma'am. Yes, ma'am. Sure.
Sorry.
Got the microphone again.
Newton
All right.
was
It
the
was, it was Officer Newton.
I don't believe Tyndale has testified at this moment.
That's right. It was Officer Newton. Okay. So let me just make sure we're clear. And I do recall the testimony. It was Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I am only going to ask Sergeant Tyndall about things the honorable court permits. From what I understand right now, that is not permitted. So no, ma'am. I
Well,
do not.
that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's
Correct.
just flesh this out now, make sure we're on the same page.
So the contents, that's what's important to us, because I think it will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the honorable court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, so I won't go into that, Your Honor. But if the honorable court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
All right. Thank you, sir. All right. So I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make
Sure.
it clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that it's non-hearsay because they're computer-generated records. That's the only disagreement. And
Okay.
of course, the honorable court issued its order on that.
Sure.
I just wanted to make that information clear.
All right. Thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records, can testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yelmichili, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information, since they are, the officer's statement and affidavits for purposes of receiving court orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it, and also contain, their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, care to be heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yalamanchili, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the contents of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right. With regard to Keshana Armstrong, or is it Keyshawn Armstrong? Keshana. All right. There was a motion in limine regarding any comment about another person with a name. Was it Scott? Was that? Hold on just a minute. Let me make sure I've written this down right. Did you make the motion about Ms. Armstrong? Was that you, Mr.?
I don't believe the state has any motion in regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not. You didn't bring evidence. Bolden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton?
Barden.
Barden. Sorry, Barden. Okay. I'm not sure I wrote it down. And you were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge. It was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr. Barden, and then also an individual by the name of Anthony Little. Okay. These would be two people that were considered persons of interest at the time. Okay. However, no information was developed to link them to the crime, and it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit testimony regarding those individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion in limine has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information.
Okay, camera person, you might want to take the camera off of Mr. Cruz when he's speaking to what I believe is his paralegal about his strategy, because, there's lip readers out there that are going to report back exactly what he's saying. How about let's focus on the judge who's actually speaking. Look, he's trying to talk to somebody in the gallery, and he says something that looks like, "Are you ready?" But the camera person should not be focused on him. This judge will do everything she can to try and get the cameras out of there. She's already told media that they're not allowed to report on juror expressions, on whether they're taking notes, on what how they're dressed. It's insane. So whoever the pool camera is, maybe you should get your focus off of Mr. Cruz while he's speaking to part of his defense team.
Suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. You have the information. Fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Baden and Little, last names?
Baden and Little.
Baden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the honorable court, our position, that nothing changes from our position.
Okay. All right. Thank you. I'm going to grant your motion. It does violate the Saudi motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another
Do you though? Do you?
piece of this that I think because Mr. Yalamanchili and I are kind of splitting up potential defense witnesses today, Mr. Newton also spoke with an individual at the Clarke County Jail back in March of 2001. That person provided some other names of people who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke, her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. These are not as it relates to Mr. Little or Mr. Barden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential alternate perpetrators also be excluded.
All right. Thank you. Mr. Cruz.
Just for clarity, Your Honor, and I may have said it wrong or misspoken,
Okay.
but these individuals, I'm not saying they committed a crime. I understand the state's alternative perpetrator ruling. I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Barden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. Anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether, did you have notice of this fact? Did you follow up on this fact? If not, why? That's our entire theory with the witnesses. As far as the witness Mr. Bowden is speaking about, I just want to make sure we're talking about the same witness. May I see because there is one I wanted to discuss with.
All right.
Mr.
He wants to show that the investigation was shoddy. That's different than a third-party culprit.
So I, in fact, do intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to an inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in sir rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief, but if there's rebuttal, this testimony will become relevant as sir rebuttal, depending on what the state's rebuttal is. So I would ask the honorable court not to make a ruling at this time until defense rests and the state lets us know if they are going to have rebuttal evidence in regards to the evidence that we present.
Okay. I'm not really sure I understand what you're asking, Mr. Cruz,
Again,
about
You're not
the
sure.
rebuttal evidence, but I do want to respond to your arguments that relate to the state's. I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Barden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any testimony about Mr. Little.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice, and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a hearing so that we can determine whether the statements being offered about alternative suspects are admissible for lots of reasons, whether they would be admissible with regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating, well, we're asking to admit those statements under a different theory, it is not appropriate for the court to allow that, because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects,
It's not about other
for the
suspects.
purpose that you're asking for them to be elicited, notice under the Saudi motion we've been talking about had to have been done in order for the court to have in order for the state to have gotten the required notice, and in order for the the court to have set a hearing date in order to flesh this out. And that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason. And I'm not commenting on that. That may certainly be a strategic moment on the defense's part.
Oh, well, let him have some.
But it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right.
Yeah, I wanted to make it clear that you didn't do what you should have done, and you didn't give the proper notice and blah, 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 blah. Massachusetts calls this a Bowden defense, Bowden, a Bowden defense, that you're saying that you're attacking the police investigation and that you're saying that the police investigation was so bad. And in Massachusetts, you have to give notice of a Bowden defense, okay? There is no comparative law in Georgia. So there is no law that says that I can find, or case law, that you must show notice when you want to show that the investigation was shoddy. But she will twist herself into a pretzel to try and find something to say that you should not be allowed to show that the investigation here was shoddy. You can't use it as a shield and a sword. You can't say to the defense, well, this is a cold case, and so therefore things are much different, and we have to grant much more leeway when it comes to construing the evidence in favor of the prosecution for purposes of your motion to direct a verdict in favor of your client. And then say, well, you can't show that the investigation was shoddy because you didn't give notice. Come on, man. Come on.
Let me start again with the state. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk with everybody because we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and get that set up. I'm going to give
Really
you all
hard.
till 10:20.
2 minutes.
All right. So that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right. We'll be in recess until then. Thank you.
Well, it is 10:20, so we're going to move.
Speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust would need to be a part of that discussion as well.
He can absolutely remain here. No problem.
He can remain here. So is everyone going to have to vacate the courtroom? Like they won't give them a conference room to speak to their client. Let's go and see if we're in real time yet. I mean, and see if she came back at the proper time. I know this is painful. It's painful to watch. It's painful to see. A Saudi motion. I saw some comments fly by about what is a Saudi motion. SODDI. A Saudi defense in Georgia. SODDI. Some other dude did it. It's a legal strategy where the defendant acknowledges that a crime occurred, but argues that someone else is responsible. The defense is commonly employed in Georgia criminal trials involving violent crime. Here are the key aspects of the Saudi defense and related motions in Georgia. And you do have to give notice when you want it. They call it third-party culprit in Massachusetts. We saw that in the Karen Reed case. Here are the legal requirements and admissibility. Direct connection is required. Evidence supporting a Saudi defense must directly connect the third party to the body or the essence of the crime. Well, they have that with Chris Melton because they have his DNA and his hairs on not only the victim, Tara Baker, but also on the murder weapon, aka the power cord. There's a limitation on evidence in that any evidence that merely casts suspicion on a third person is generally not admissible. And they also have to make a motion, or they have to either make a motion and they have to lay out all of the reasons why they think that they should be allowed to point to this third party culprit. And that was ruled in favor of them pointing to Chris Melton, but only Chris Melton as the some other dude who did it. And so that is why she is apparently twisting herself into a pretzel to say that they should not be able to point to anybody else that that law enforcement may have considered to be a potential suspect in this case. And there were many. I'd like to know if any of them were Black. And the reason, okay, so the reason that it's hearsay is because the judge is not going to allow John Newton, he came in on day 4, to testify about his conversations with, what was her name, Jessica Gann, because they're saying that is hearsay, because it's being offered for the truth of the matter asserted, in that Jessica Gann said she saw Tara Baker at the Mexicali Grill the night of her murder around 9:30. So he can't ask Newton if he had that conversation with Jessica Gann, even though it's in the police file and he did have that conversation with her. But it seems like if Jessica Gann comes in to testify, which it seems like she's going to, that she may be able to talk about what she told John Newton. Because it doesn't seem like the state was arguing against that, just about asking Newton about that. So thank you, Iceman, for being here for 5 months. And that was a good question. Thank you to Deborah Guzman for gifting 5 memberships. You're amazing. Thank you so very much. Bethany is here, and she said, I just want to let you know I bought the sleeping Bluetooth headphones I saw on your Amazon. Oh, the ones that are like a headband and also an eye mask. I love those for the plane. And they're like 2 for $20. I know they're great. They're perfect for when my husband is sleeping and I want to listen to true crime podcasts. I love you with all of my heart. I love you with all my heart. Thank you so much, Bethany Rose, for your super chat. Charlie is here from Australia, and she says he hasn't even started yet. And the state is whining. I know the state is whining. Meanwhile, the jury is waiting in the side room, says Charlie. Johnny, New York says, but it's a cold case. I thought latitude was in order. WTF. Yes. Great minds. Great minds. I mean, so here's the thing. Anybody out there who has Sprint as your provider, if you committed a crime when Sprint was in business, here's some precedent for the fact that your phone records should not be allowed into evidence because you can't call anybody in from Sprint to authenticate them. Oh, please. Thanks, Johnny, for your super chat. David Reese is here and says, I want to know what's in the phone records that the state is fighting so hard to keep out. I don't even know whose phone records they are. I think they might be Chris Melton's, but I'm not sure. Thanks, David. Unbroken says, I've never seen a defendant not be able to defend themselves. Oh, we have. We've seen it quite a lot. So welcome. Welcome, Unbroken 1972. Thanks for your 5. Judge Lott has lost the plot, says Charlie. Charlie, well, you're on it today. You are well done. Oh, yes. I think that's what it was, maybe, right? Yeah, Sarah. I think there were 5 calls with Chris Melton. Weren't there something like 5 calls with Chris Melton the day before Tara Baker's death? Did that come in? And it may have shown right how long they hadn't talked before that. Interesting. Elemento G says, why is he having to flesh out his whole case? This is how she does it. This is how she does it. They do this. They get his whole strategy. They try and get all of the questions that he wants to ask the witness. They have the witnesses sitting in after the jury leaves, while the attorneys are arguing about what the witness should be allowed to say and not allowed to say. There was a pretrial motion about that specific issue in which the defense said, listen, this has been going on in pretrial hearings. We don't think the witness should be here because it's coaching them on what to say. Judge denied it. Unbroken says, Georgia law is lot law. Thank you for your super chat. And Amanj says, thank you for your $5 super sticker. I appreciate you. Karen DePasquale gifted 5 memberships. Thank you so very much for your generosity this morning. Danielle Sky says, my 6-month-old grandson loves you. Thank you for your super chat. I get that a lot. That babies love my voice. I don't know why that is, but I'll allow it. We have baby merch in the merch shop. I think some of it is linked to the stream. So if you want to dress your baby up like a cupcake, you can do that. We have onesies. B-May 28 says, so all exculpatory evidence is confusing the jury. If the state didn't admit something, it's too confusing. This is maddening. I'm behind. Forgive me. You're forgiven. Thanks for your super chat. And your observations are spot on. She said they were coming back at 10:20. It's now 10:29. They were not back yet. Andreas says, can you say again what junk science they let in? True allele DNA has issues, as does the Lugol iodine test. The Lugol iodine test, Zoe, if you're here, the Lugol iodine test, they flew a witness in from California to say that they did some sort of presumptive testing on the oral swabs and that one of them may have had vaginal epithelial cells in them. So it must have been mislabeled. That is typically something that is not allowed because it's not a confirmatory test. It is a presumptive test. If I'm picking up what they're laying down, and Zoe, I know if you're here, you know a lot more about this than I do. So the junk science has to do with the DNA evidence. Thanks, Andrea. And I hope that the defense has an expert to put on to talk about why that's junk science and why it's unreliable and how there can be false positives. And I still want to know how you can take an oral swab from Tara Baker's mouth and have none of her DNA on that swab, only Edrick Faust DNA. Explain that to me. If anybody can explain that to me, please do. Dying to know the answer to that. KLM Kathy Rustin saying a few sign holders outside of court protesting. Yes, one of our cupcakes in court today said that she did see some protesters outside of court with signs, and I'm good. Good. Amanda Husky Mom says junk science is the DNA and the partial DNA is the only thing they've got. Right. Sarah says, yeah, but one of the labeled oral tests only had Faust's DNA. That means Tara Baker's DNA was not on her own oral test or on her own vaginal test. How could that be? How could that be? That you take a vaginal swab, even assuming that they're right, that it was mislabeled. First of all, I think it's BS that there would never, ever be two oral swabs from a victim, but assuming that one of them was mislabeled, which automatically goes to, you know, the carelessness, right, of the lab or whoever labeled them, which should be taken into consideration by the jury. But how can you take swabs from the victim's own mouth and the victim's own vajayjay and have one of them have zero DNA from the victim? That's impossible, right? Wouldn't it be more possible that they sent by mistake, let's just say, let's give them the benefit of the doubt, that they by mistake sent in one of Faust's buccal swabs to that lab in California, right? That's what I'm saying. And I hope they argue that in closing, the defense. I think, Zoe, I think I heard you say the same thing that I just said. But of course, the chat's flying and I can't find it right now. Well, here you go. This is the only available names. This is the only available name. Well done. Says quick perplexity search says 2 oral swabs are standard for SA kits, sometimes more. I don't believe there was only one swab. I don't believe it either. And every single, expert witness who was asked that question, would it be unusual to have 2 oral swabs? They also tried to twist themselves into a pretzel to say, oh yeah, it would be unusual. It's crazy, right? Bethany says, Mr. Cruz has such a respectful and gentle heart, which is admirable. Makes me wonder how Alan Jackson would respond to this judge's nonsense. He takes no BS. Thanks, Bethany, for your 5. Charlie says, after Lot's word salad, Cruz should have said, sorry, can you repeat that? Or let me make sure that I understand you. Johnny says, Sprint shows gap in calls, i.e. break up until the day before. Right. And did Chris Melton say that they did speak 5 times the day before? Because now I could be conflating the testimony during the trial with the pretrial motions that I read. And so I'm not sure. So if you guys remember, if Chris Melton testified to that they spoke 5 times the day before her murder. I mean, listen, did we even have a time of death? Was there even an estimate on time of death? Who's to say she wasn't beaten the night before, and then she could have been strangled and stabbed in the middle of the night, and then the fire could have been started later than that? I'm not so convinced about the time of death here. And she had just showered. Her hair was wet. Somebody smelled shampoo. And yet there's still DNA from an encounter that she may have had with Chris Melton 10 days before. And then in 2024, he's coached by Liz to shorten that time frame because the DNA wouldn't stick around that long. Make it make sense. I don't believe the drainage BS at all. And they lost the clock, right? So maybe it stopped working days ago. I still don't even know what kind of clock it was. Was it a clock that had hands on it? Was it a digital clock? How long does it take to appeal a case? Unbroken wants to know. Well, I mean, after a conviction, years and years and years and years. Takes a very long time. So many things are very unclear about this case. Oh, thanks, Bets, for your 10. She says, she's awful and I'm outraged. Love you. Love you too. It seems to me, based on the violent nature of this crime, I mean, they talked about horrific bruising around the JJ and her butt. Horrific bruising. She was brutally raped, sodomized in both places, orally and anally, beaten to a pulp, strangled and stabbed. And nothing was missing from the apartment except for her laptop, which was never recovered. What does that indicate to you? It seems to me that this was something very personal. If this was a burglary or some type of robbery, wouldn't other things have been missing? Like the heirloom jewelry that the roommates had, the diamond stud earrings that were still in Tara's ears when she was found. I don't know. Hopefully the jury can use their common sense, and hopefully in their closing, Mr. Cruz is going to hammer on reasonable doubt. Thank you, Elaine, for your very generous 100. She says, as always, thanks for all your coverage. Thank you so much for thanking me and for being here. And to each and every one of you who has chosen to follow this trial with me, thank you so much for being interested in this, because this is one of the worst miscarriages of justice that we've seen in a very long time. Jessica, I need the link to your channel. I need the link to your channel. Just email that to me. And I can see if I can try and fix it on my end. Tell me if you think this is worse than Karen Reed. Mel said, I asked my doctor about drainage and he said, no way. Thank you, Mel. For your deuce, Bethany said, yeah, you did miss the daily affirmation. You did miss it. Here's the daily affirmation today. Start where you are, use what you have, do what you can. There's another quote that I got today that I thought was on point. And this is a quote from Napoleon. Never interrupt your enemy when he is making a mistake. Never interrupt your enemy when he is making a mistake. Another good one. Somebody may have needed to hear that today. Kathleen says, did the medical examiner testify her lungs showed smoke inhalation? I thought he did. Remember, I think he was the first witness called. I think he did, because in opening, the prosecutor opened on she was still alive when the fire was set. I remember that. Mystical Beowulf says was Faust with her at all. We don't know. We don't know. The only person who could tell us that was Faust. We watched portions of his statement to police. Yes, soot in her airway, right, Zoe? Yeah. So, but in her airway, but was it in her lungs? Soot in her airway could have fallen in after death if her mouth was ajar in any way, right? Mystical's here from Australia. He's the only one who could testify to that. But when the portions of his statement, his video recorded statement that we saw by Liz Bingham and Liz and Jeremy in 2024, after his arrest, he was cuffed and brought in and was told that he had 9 warrants for his arrest and he had no idea what they were about. I can't believe he talked as much as he did because he's been in the system before and he should have known to get a lawyer, but maybe he thought it was like traffic tickets. He had no idea why he was there. And when she's like, she uncuffs him and she's like, "Are you going to act right?" And then at one point she says to him, "Do you know how to read?" I would love to see some other this was her actual first cold case that she investigated as part of the cold case team. This was the
I'm
first.
getting this to you in word format.
Here we go.
I'm sorry.
They're back.
Getting the jury instructions in word format. I understand you received it.
Oh, that'd be great. Thank you. All right. Let's go on the record. Mr. Cruz, have you had enough time to have the conversations you said you needed to?
I have, Your Honor.
Okay, very good. Are you ready to proceed?
We're going to close the evidence, Your Honor.
Okay,
What?
so you're going to rest.
Yes, ma'am.
All right.
Wow. No case. They didn't put on a case.
Let's talk about a few things.
Wow. They're not calling any
We're talking about
witnesses.
timing, some timing issues. Let me just have counsel at the bench so we can sort of have a more of a free-flowing conversation.
I had a feeling this could happen. I had a feeling. The defense has rested. We might get to closings today. And you know what? I bet you Mr. Cruz is ready. I bet you Mr. Cruz is ready to close. And I bet you that the DA is going to be like, "Yeah, we need time. We need time. We need time." Too bad. Too bad. DB says they can't call anyone. It's better for the appeal. Yeah, if their appeal is going to be based on like there was zero evidence to convict him, I thought this was going to be a good call too. Because I was thinking last night, I'm racking my brain. I'm thinking, who could they possibly call that would move the needle at all? Unless it was a DNA expert to come in and talk about the junk science. And I think they're going to argue the prosecution has not met its burden. They can't even prove that my client was in the house. And if DNA can linger on a body for 5 days or however long, maybe Mr. Faust came into contact with her somewhere else. But they could not prove that he was in the house. And if he was never in that house, then he is not the one who murdered her. And so I think it could be a good strategy. If they close this morning, the jury's going to get the case this afternoon, but they haven't had their charging conference yet, actually. So that is something that would have to happen before closings, I believe. So they may go to charge conference right now. Let's see what happens. And we saw this happen in the Brian Walsh case. They did not put on a case. They rested. So we do see this. And I think there's more than one case that we saw this in. Penny McGee, I don't think they put a case on, right? JoJo's grave concern says they don't need to put on a case. It's clear cut. They're now having a conversation at the bench, and we will see what happens next. If you are going to sign up for YouTube Premium, don't do it from your phone. Do it from a laptop because they charge an extra VIG if you have an iPhone for the Apple Store. CatQ thinks it's a brilliant call. I mean, tell me what you think. I think when I went back and watched the video again of Faust's interview, he was genuinely shocked. He's going to have to rest on the record. So we will see it again, or we'll see him do it maybe in front of the jury. But he looked to me like he was genuinely shocked. And it seems to me that if he committed a murder in 2001 in that neighborhood and he was arrested, a regular person would be thinking, oh my God, they finally caught up with me. Uh-oh. And he would have lawyered up instead of talking to them. Zoe says, bold strategy by the defense team. I do think it's the right decision for this specific case, even knowing juries tend to think the defense needs to put on evidence. Right. He's got to talk about how he has no burden. And I'm sure he will. He's experienced. A lot of people seem to think that he's, totally green. But these are people who did not read the pretrial rulings, apparently. And I think that the jury got to hear from Faust. And so I don't know. Let me know what you think. One moment. I like it. I don't know that there's anyone they could have called. Oh, Baby Doll says, Chris admitted on the stand what he did. We all caught it and heard it. I played it back a number of times. I'm not as convinced that he said something like, I didn't want to see the devastation that I caused, or if he said, I didn't want them to see the devastation that it caused, or it was hard to tell, but I mean, a lot of people feel a certain way about it. And I could see why you would, because it was unclear what he said. Thank you, Law Mom. Mr. Cruz is not a green attorney. He's practicing in a district he doesn't usually and dealing with a difficult judge. Yeah. He's a big city guy. And we saw this when Alan Jackson came into a Massachusetts courtroom. Judges don't like the big city guys coming in. It's not the way we do it here, Mr. Jackson. I don't understand what you're saying, Mr. Cruz. You needed to do this, that, and the other, and you didn't do it, Mr. Cruz. The public spankings in this trial have been a little bit over the top, in my opinion. Brittany says, one big question from me is how Chris Melton knew when he said, I'm hearing there was DNA from me and another guy or something along those lines. Hear from who exactly? That info wasn't out yet. No, I think they told him. Wait, you mean back in 2001 or 2024? 2024, they straight up told him that there was other DNA. And that's when he said she must have been with somebody else. But I don't remember that from the 2001 interview. OMFGY says, didn't Lott deny Mr. Cruz a rebuttal DNA expert? I don't recall. I'm not aware of that. Admittedly, I've not read every single. We need to explain away your DNA. Right. That's what they said. That's what Liz said to him. I don't know that if that was in the pretrial rulings, because that would be wild if it was. And then that would be, grounds for appeal. Not that there aren't a couple that I could think of off the top of my head. The only thing I agreed with that she said today, her ruling on, or her comment, it wasn't even really a ruling, was it? When she says that she was told that by Ms. Satterfield, the court reporter, that 2 employees from the defense firm asked her to read back testimony to them. That is totally improper. They're not allowed to do that. I'm not sure that's exactly what they said. They may have said, can we get a read back if we need one? Or do we have to order a transcript or something of that nature? I don't know what system they use there, if they use a recording system where the court reporter speaks into a microphone, or whether they do old-fashioned stenography, typing things in. I guess the jury's coming in.
Thank you. You all may be seated. Welcome back, ladies and gentlemen. Appreciate you all again being here on time. We are ready to resume State of Georgia versus Edrick Faust. SU 24 CR 0547 is state ready. State ready?
Ready, Your Honor.
Defense ready to proceed?
Yes, ma'am.
All right, ladies and gentlemen, the state has rested. Mr. Cruz?
Defense rests.
The defense rests as well. Ladies and gentlemen, that means the evidence in this case is closed. So now this is what we are going to do. And I want to tell you sort of how the process works. The evidence is closed in this case. And the next step for all of you is to hear closing arguments. There's something that has to happen before that. And it's called a charge conference. And it is a conference. It's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done outside your presence, as we have done many things outside your presence during the course of this trial, including this morning, which is why I had you come in later, because we were doing things outside your presence, and I just didn't want you sitting in the jury room for, when you could be at home or doing other things. But this charge conference, of course, must happen outside your presence, and it's going to take us a while to do it. I'm going to give you a very long lunch break. I'm going to give you a lunch break until 2:30 this afternoon. And so I'm going to ask you to return back here at 2:30. I know one of the jurors has an appointment. Don't rush to come back. If you're a little bit late, it's fine. We will not start without all of you being present, so don't worry. But if you'll come back at 2:30, we're going to begin closing arguments at that time. The same instructions I have given all of you apply. Right? Don't discuss the case with anyone, of course. Don't do any research independently or on the computer. Please don't go to any of the locations you may have heard about. Enjoy your lunch. It'll be a long one, but we'll see you back here at 2:30. Thank you very much.
So closings at 2:30. Depending on how long the closings are, they may get the case today, or she may have them come back and start deliberating on Monday. Well, wait, is Monday a court holiday in Georgia? Monday is President's Day. It's a court holiday here. We have no courts open here. I think it's a federal holiday, so I'm assuming that they're closed on Monday. And if that's the case and they don't come back until Tuesday, it may be a shorter deliberation, but they're not supposed to talk about the case until then. So we're going to do it. They're going to have a charge conference now, and the jury gets lunch until 2:30. Racing Queen says, why does the DA do motions on something based on what the DA believes the defense plans to do? Can't they just object if those things arise? They're motions in limine, and they try and work them out before the witness testifies. And the defense isn't going to put on a case. So none of that stuff is an issue anymore.
Thank you.
Thanks for your 5, Racing Queen.
All right, we're going to be in recess till Ms. Ellis is finished with compiling the charges from the state and the defense, and then we'll be back on the record and we'll have our conference. All right, thank you. Court is adjourned for the moment.
For the moment. Court's adjourned for the moment. Wow. This is going to be an interesting Friday. Everything happens on Fridays, right? Seems that way. Johnny says it's almost worse than Richard Allen. Richard Allen, we didn't even get to see Richard Allen. And that's why this is worse, because we are actually watching it. In Richard Allen, that's the Delphi case in Indiana. If you're not familiar, we had to rely on court watchers to give us all of the information. And depending on who you watched, you might get a different version of what happened that day, or different opinions of what happened that day. Andrea Burkhart took copious notes. Her notes were amazing. She's a law tuber, and she went live every night for like 5, 6, 7 hours reading her notes. It was wild. So it depends, because we didn't get to see it. Right, Johnny? Thanks for your deuce. Lucy says, I wish Cruz had used state witness to point out studies for optimal collection of DNA. After intercourse would have been way less drainage. Well, it's always easy to Monday morning quarterback. I think they did a great job with what they had and what they were allowed to put into evidence. And I think some of the rulings that the judge just made about the phone records and about what certain witnesses were going to be allowed to testify to could be all issues on appeal cumulatively. The defense has rested. We are waiting on a charge conference. Oh, please. Putting on a case, and it's a strategic move. Kat thinks it's a brilliant call. E. Frey notes says, I find it difficult to believe how DNA in the rectum could be attributed to an encounter 5 to 10 days earlier and how no DNA would be present from someone who allegedly brutally assaulted her on the 19th. Me too. And hopefully there's someone like you on the jury who gets it. Karen said, great call by Cruz. He has tons of reasonable doubt. Thanks, Karen, for your 10. Ellen, thank you for gifting a membership. Nick is here. Hey, I sent you an email. Thanks again for the last time you showed up on my panel show. Thank you, Nick. I'll take a look at my emails probably after the show is over. Ashley says, how did everyone still smell shampoo after being in a fire? You can't walk by a fire and not smell like smoke, right? I can't even sit by a campfire or a bonfire and not have my hair smell like bonfire smoke for days. Well, no, until I wash my hair. But yeah, agreed. It's kind of weird, but I think there was more than one witness who testified to that. All government offices are closed on Monday, says Becca. Okay. Somebody else had looked up the court calendar and said that they took that holiday on a different day. And so I was a little bit confused, but to be honest, I did not look it up myself. Back to the chat. What do you guys think? Yesterday, I think we had 93% saying not guilty. If you were on the jury, what would you be? What part of the testimony or the evidence that came into the trial would be most convincing that you would use to try and convince the other jurors of your position, whether you think he's guilty or not guilty? Let me know. Sarah says Liz's testimony saying Chris couldn't have done it since he was in a relationship with Tara sealed it for me. Not guilty. Buttercup says it's a chess game. Trial Addict says wet hair won't burn. Karen says, I stand corrected. Athens-Clarke is a state and local court and will be open on Monday. Well, I don't know. I guess we're going to find out when the judge tells the jury when to come back. Allison says, every social media outlet I've seen on this case agrees totally with your chat. Not guilty. Zoe says, I looked up the court holiday schedule on the court's website. They do not observe President's Day in February, so court should be open. All right, well, no 3-day weekend for us then. Here for the tea says, Jeremy said there's no way her shampoo could have been smelled. Jeremy's spoken. Oh, look at this. Guy and Ben's mom says, inspired by you and the cupcakes, I start college at 55 for forensic investigation. Thanks to you all. Well, good for you. You're never too old to dream a new dream. I tell you guys that all the time. I'm so proud of you. I'm so happy for you. Toxic great granny confirming that our courthouse is open on Monday. They deferred it to Christmas time. Awesome. No, she's not sending them home. She sent them to lunch until 2:30. We are waiting for whoever is in charge of typing up the jury charges to type them up so that we can watch a charge conference on what instructions the jury will be given. Jury instructions are really important. The cupcake thing thinks that it was what they call a crime of passion, not a stranger. We're not off until 2:30 though. They're going to come back and do a charge conference. Oh, that's right. Robin says, plus Cruz has his flip chart of notes, right? The big Pictionary pad from the witnesses. The close will be fire. Elaine says that her best argument would be the DNA to convince the other jurors. I don't need a badge says, I think Cruz will be able to line out the evidence really well. In closing, the recap of evidence in the trial would be reasonable doubt. Easily, yep. And he's got the pad. He's got the pad that the jury saw him writing on in real time. And some of the witnesses, he had writing on them as well. Hi, Sherilyn. Sherilyn says it could have been G, your hair smells terrific shampoo. Remember that? Yeah, but that wasn't the name of it, though. I think, was it Herbal Essences? But that was their slogan. Gee, your hair smells terrific. Or was Herbal Essences the one that had their commercials were she told two friends, and then she told two friends, and then so on, and so on, and so on. OMFGY said Chris's lying would be what I would try to convince the jury about. Lucy says, it's crazy to see what people are saying in other chats. Oh, trust me, all the wackadoos are emailing me with their wackadoo rage baiting nonsense. So yeah, I don't even look over there, but I can imagine what you're seeing. Britt says, Chris's DNA would be my argument. Bleachers says she may have been in the shower when the house was broken into. Well, first of all, there was no sign of forced entry. But yeah, she was naked. She was naked. That's a good point. That is a good point. Bleachers. I never really thought of it that way because she was naked and her hair was wet. Dr. Brian said Melton's testimony. Memory says no investigation of Faust at all. Twilla says junk science. Summer Coffee Trials Cupcakes says Chris Melton testimony and argue the DNA. Indie Girl says Chris DNA. Frankie Bean says the DNA. Tiddlywink says the DNA. But there are some people out there, and if you're watching the other chats, you know, who will believe, who may believe that if Faust DNA was there, there's no way that that could be a mistake. Therefore, he absolutely 100% did it. There are some people who believe that about DNA. We do know that it was not seminal DNA because we do know that the GBI tested for seminal DNA and it was negative. Right? CJ says that Chris not going to the candlelight vigil was sus. Jimmy Baker says the witness that could not say the DNA was outside of her body in the house. Poetic Justice Podcast says the fact there was no DNA in the house. Zoe says Chris's DNA being in places and concentrations where it shouldn't have been if he hadn't had contact with her in 5 to 10 days prior, like he claimed. Elaine says only Edrick's DNA is found in her mouth, not even her own DNA. JoJo's grave concern says the mislabeled swabs. Court's indulgence thinks that Cruz is a mess. He lacks respect for the court and can't even call and let the court know. Decorum. Are you aware that his wife was rushed to the hospital the day before that? And maybe, just maybe, he was focused on his wife getting better. And also, it seems that the judge's email just said, I will see you at 9 a.m. tomorrow. And so he just showed up at 9 a.m. tomorrow. Thanks for your thoughts. Nurse Not Lawyer says, Chris Melton is huge reasonable doubt, not guilty. Brit Being Human says, our friend E is very well represented. They've been handcuffed from jump and they still fought like champs. Kiki Kazoo said, his DNA would have been all over the room and her body. Charlie says, how big is the screen window? They showed photos of it. I forget during whose testimony they showed photos. It was a regular size window, single, what do you call it? Like a single frame window, like big enough for somebody to crawl in and out of. But the blinds on the inside were undisturbed. So I don't think that's what happens. And they were those flimsy rental vertical blinds that are so easily bent. Anybody whoever had those blinds would know. Johnny said, did the cops even verify that Nash Plumbing existed? Thanks, Johnny. He didn't remember that he didn't know the phone number of Nash Plumbing or their address. And I think they never confirmed with anybody at Nash Plumbing. I don't know if they ever confirmed that it existed. I don't recall that testimony. Charlie says, not guilty, no forced entry. And remember, we learned that Tara's house keys were never found? Johnny said, chain of custody, country music. Yeah, the country music concert that he went to instead of his borderline fiance's candlelight vigil. Thank you, Evolve My, for saying that my commentary is fire and for your $10 super chat. I appreciate you so much. This person, CPT Jaxie 1925, said, got to make the motions and state the law, rookie lawyer. He's been making all the motions. He made at least 5 motions for a mistrial, I think, at least 4 that I can recall. And he's been bringing case law to every single motion. So I'm not really sure what trial you're watching, but go on with your bad self. Melissa says, was Faust interview testimony? I missed 2 days. They showed it during Jeremy Howell's testimony, which was yesterday. I have all the timestamps in for yesterday's video. So if you're behind, you can find exactly what you need. Thanks for your super chat. Yeah, Happy Days says that Chris Melton's pubic hair was on her buttocks. Yeah, that is very strong evidence, in my opinion. Very. I don't care if there's, fire hoses in the room that were blowing around the hairs that could have been all over the house. The fact that the only hair found by her butt was Chris Melton's is very strong evidence for the defense. No, the charging conference, don't get confused. The charging conference is not happening at 2:30. The jury is not there for the charging conference. The charging conference is going to happen shortly after they type up the charges and then argue them. 2:30 is when the jury is coming back. That is going to be when closings are going to start. So let me fix the banner at the bottom. I'm not sure who closes first in Georgia. Who closes first? Every state is different. Sometimes the state will close first and then they will have a rebuttal. Sometimes the defense closes first and then the state closes. I can't remember the last trial that we watched in Georgia, if ever. Rollerskate says they spent the whole trial defending Chris. They did, though, didn't they? Allie in Texas says the hairs in Melton's testimony. Winosaur says, I think the lack of evidence does it. Al Dente says, it's suspicious how Tara's roommate inserting how long it took Tara to dry her hair. Yeah, Ashley, was that to cover for Chris saying her hair was wet for hours? I don't know, but Ashley did wind up marrying her husband, Chris Hall, who was good friends with Chris Melton, and she may still be good friends with Chris Melton. So yeah, I would look at her testimony through a lens of maybe not so credible or maybe a little bit biased. Huh. Oh, please. We have 4 cupcakes in court today. So it's going to be, they're there for one of the best days of the trial, which is closing arguments. Yes. Claire says, Liz, previously a special victims detective, right? And she covered child corn cases, child trafficking cases, and other types of sex crimes. Not acknowledging intimate partner violence was a huge red flag for me. Misty Meadow says the drainage DNA is daft to me. Liz B from Tennessee says no proof that Faust was in the house. Darla said the presence of Chris Melton's DNA. Also, how about the fact that Chris Melton lied for 23 years when he told police initially in a couple of interviews that the last time he had been with Tara or even seen her was 10 days prior. And then compressing that timeline in 2024 when Liz said, we need to explain away your DNA. So, you know, here's the way it works. Your DNA would only have stuck around for 5 to 6 days. So are you sure? Are you sure that you saw her 10 days before? Winky, wink, nod, 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 nod. Shelbster says the Chris's timeline and is DNA contradiction. Megan says the interrogation. Happy birthday. Julie's birthday is Monday. Happy birthday, Julie. Guy and Ben's mom says, I think Chris pulled her from the shower before she rinsed her shampoo out. Interesting. Roselle says, DNA and Chris, BS, schedule for that day. I don't believe it. KB in Virginia? Chris's testimony and no confirmative DNA. Tina says DNA, Emmy testimony, and Chris Melton telling on himself. That I'd have to ask. Just Blue Lies says, with the amount of attention this is getting so quickly, the state is lucky the defense arrested before it got uglier. Yeah, that's one thing they should be thankful for today. Oh, Sarah says, why take photos of Chris's hands if they knew it didn't happen until after? Shady. Interesting. Semantic says, I pray the jury sees this mess of a case for what it is. I'm sorry for the Bakers, but the investigations were not good. Autodoc says, just the fact that the state started and focused on defending Chris, why would they do that if they have proof of someone doing it? Jennifer says, the fact that the DNA from both of them was on her and the fact that Chris was all flirty with other women right after he died, right after she died, right? He went to the country music concert with one of her besties who gave him permission to go out and have fun instead of going to the candlelight vigil. The girl that they were out to lunch with or dinner with Ashley, and how he was rubbing that girl's back. And he said he was just trying to comfort her because they had all been in the same trauma together. Did you believe that explanation? Sarah says the fact that there were two stories about Chris Milton punching the wall. Mike says not guilty 100%. Liz will be pissed. There is going to be court on Monday. We've confirmed it. Holly says that Chris was totally unreliable as a witness. Creating Through Chaos says Chris's meltdowns, weird testimony also sealed it for me. He's a strange man and his testimony was bizarre. Sarah Juror says, I was playing pretend last night like I was a person on the jury explaining why somebody thinking guilty should change to not guilty. That's so funny that I just asked you that question. Great minds. And I was going on about DNA is not reliable. Or this particular method of testing DNA is not reliable. Court's Indulgence says, not guilty, but not because of Cruz. He was awful. Again, did you watch any of the pretrial? Did you read any of the pretrial motions? Do you know what he's been up against from the beginning, being the big city lawyer from Atlanta, coming into like small town Athens-Clarke County, Georgia? You're entitled to your opinion, but I'm just wondering if we watched the same trial. Or if maybe you're just a troll trying to rage bait me. It's not going to work. Natalia says, too much reasonable doubt, not guilty for me. Ellen says, Elle says, Chris's DNA being present and lack of confirming his alibi. Mimi's in the house and she says Chris's DNA all over everything, his lies, unclear alibi, his injuries. M. Oslin says the combination of Chris's testimony and his DNA and the fact that they bent backwards to defend him, 98% of the trial was about Chris. Cherie says, I have not seen one piece of evidence that would have me vote guilty. Oh, please. Oh, please. Oh, YouTube, you and your issues are going to just make me crazy. All right, Jessica, you look okay on my end, but try now and see if it's if you're able to chat. Susan says no victim DNA on the swab. Oh, Shauna Reed says, why are they actually prosecuting him? I don't understand. Well, let me show you something. Let me show you something. Looks like they may be getting ready to come back, but in 2023, July 1st of 2023, Georgia enacted the Coleman-Baker Act. The Coleman-Baker Act, part of it was named for Tara Baker, the victim in this case. And so what better proof that the Coleman-Baker Act is working than solve the cold case of Tara Baker, right? And we even heard Liz testify that it was the first cold case she was assigned to when she joined the cold case unit under the Coleman-Baker Act. Here's the Coleman-Baker Act. I don't know why this is not opening over here. Hold on one second. Technology is not my friend today. Oh, it's Friday the 13th. Is that why? Maybe. Here's the Coleman-Baker Act and its application. And look what you need to show in order to have a cold case opened under the Coleman-Baker Act. It says, prior to acceptance of an application under the Coleman-Baker Act, the GBI shall verify, that's the Georgia Bureau of Investigation, the crime is a murder as defined by Georgia statute. The murder occurred on or after January 1st of 1970. The murder occurred 3 years prior to the date of the application. The initial investigation of the murder was completed by the GBI Investigative Division. All probative leads have been exhausted or no likely perpetrator has been identified. There it is. All probative leads have been exhausted or no likely perpetrator has been identified. So in order to reopen Tara Baker's case, they had to show that Chris Melton should not be considered a suspect. Why Say My Name says, I don't like that the prosecution uses the Coleman-Baker Act named after Tara to guilt the jury to convict to show the act is worth it. Right. Agreed. Agreed. Same. Semantic said, Liz is the TV-friendly detective. Scott usually only officers with many years of experience get to work cold cases. It was a brand new unit. There's a brand new unit. Martin says, were the two detectives on first name basis with the defendant as with Chris? That would just be another discriminatory factor Mr. Cruz could also point out. Well, how about like, you do know how to read, don't you? You know how to read, don't you? Oh, so you were close with your stepmom and not close with your real mom? Oh, did she owned that house? Your stepmother owned that house? Like some of the questioning was just so, I don't know, offensive to me. Was it offensive to you? Johnny said Coleman-Baker Act and freight train and state manufacturing. Chris Melton's DNA alibi, zero follow-up on many investigative leads. Chris Melton's hands and testimony, not guilty by a long shot. I don't know if they were able to get the testimony in about the zero follow-up on many investigative leads, were they? Yeah, the Citizens Roundtable. Remember the citizen investigator that came in to testify? I was like, that was crazy. Ashen Sugar says nothing but DNA against Faust. So much DNA, so much more DNA against Chris. Right. Yarn Workcraft says, who decides or who concludes that the boyfriend's DNA is supposed to be somewhere regardless, right? And that's what's so wild to me is that she worked in child trafficking, child sex crimes, and other things, as if boyfriends never grape their girlfriends. That never happens. So the DNA is supposed to be there. Charlie says, can the jury take the defendant's papers into deliberations? I don't think they're going to be entered into evidence. So I don't think so. Maybe. It depends on the state. And so I can't give you an answer on that. I remember when one of the demonstratives used in Alan Jackson's closing in Karen Reed trial number 2 was a slide that we never really got to see, which was all of the points of reasonable doubt. And I can't recall if they were allowed to take that into deliberations or not. It hasn't been marked as evidence. Likely they would not be able to, but it's a great question. Hazmat says no firefighters smelled shampoo through their SCBA masks. Allison, Liz Bigham, proudly doubling down on all her shady tactics. Melton, concentrating so hard, hiding his face, brain buffering, hair on power, cord block. Yeah, the way he was disassociating visibly while he was on the stand was really wild to me. Christy says, love to hear the count on how many times Chris's name was mentioned versus Faust's. Yeah, I don't know if Zoe kept track of that. She's our resident statistician. Sometimes when she feels like keeping track of stuff like that, she does. Iceman cometh, today's my birthday. Happy birthday. And I took the day off to watch court with Mel and the cupcakes. Happy birthday, Iceman. Another Aquarius. Thanks for your super chat. Tiny Sleuth says, Chris was intimate with Tara so many days before, and she still had that hair in her butt. Is the state saying she didn't know how to shower properly? Well, his hair was also in the murder weapon, too. Thanks, Tiny Sleuth, for your 5. B-May says, the fact that he said everyone was isolating him, no one would talk to him. You're talking about Chris Melton. But he was going to lunch and concerts with her besties. So which is it? Great points. Division Bell, thanks for your 5. Georgia Code Title 17, Criminal Procedure, Chapter 8. State closes first. Thank you. And did they get a rebuttal? Probably. They always get the last word. Thank you, Division Bell. David Reese says, Liz and Jeremy are such good detectives that they didn't have to verify Chris's alibi. There was no reason to. There was no reason to, she said. There's no way he could have possibly have done it. I read his statements. There's no way he could have possibly done it. Ashley, checking in from Athens, Georgia, says, not guilty. The state did more defending Chris than actually bringing in evidence towards Edrick. Yep. I agree with you 100%, girl. Thanks for your 5. Ashley, thanks for watching. R says, so she showered normal time, was still undressed with wet hair. Faust in, out, fast, unalive, clean, start fire in time to be seen by racist tipsters. Clock stops at 9:02 as fire reached it. Sure. Sure, Jan. Thanks for your 10. I think the clock was a red herring. They also lost the clock, by the way. Melissa Garcia says the fact that he was punching walls, I always assume they are covering up for knife or scrape marks. There's no evidence for Faust. Also, love my necklace. Thank you. Oh, I'm so glad you like it. Christine became a member. Welcome. Johnny says Coleman Baker Act freight train. We just read that one, right? And state manufacturing, Chris Melton, DNA, alibi, 0 follow-up on many investigation leads. Thank you very much. Oh, hey, Bob. Bob Mott is here. Oh, thanks for your birthday wishes. I love you guys. Allie said, Cruz was in an old school gun showdown, but the judge stole his bullets. He fought his ass off as best he could, though. Marion says, hi, Melanie and Cupcakes. I pray that this jury is smart enough to see through all the BS the state was laying down and vote not guilty. 100%. It's not possible for her own DNA isn't present in her own mouth. No, there was none of Chris Melton's DNA on the knife. There was none. It was only Tara's. Let's not confuse the chat. Right, guys? Waiting for the charge conference. Sarah Juror says, I've learned nothing about Edrick. Nothing. All I learned is what Chris was doing in 2001 and what he's been doing since. I'd love to hear that for Edrick. Well, he's not going to testify. Laura says, my stomach dropped when you just read the act. They had to find a new suspect. Who better than a suspect who had a mailing address 585 feet away from Tara Baker's house and who had been in a knife incident 2 weeks after her death? And whose DNA was in the system? We'll see. We'll see what the jury does. Welcome, Cherry from Texas. Thanks for becoming a new member. Cheyenne says, did you find the prior docs for recusal in this? Yeah, I think we went over them in a prior stream. The stream that I did last Sunday. I'm pretty sure we went over them. Did we? We went over a bunch of pretrial motions. Okay. Let's see. Bottomless butt dials mess 227 says, if Liz actually investigated Chris and his alibi, we should have had a slam dunk case against Chris and his DNA. 305. Accidental juror says, so smart to rest. This judge would have made presenting a smooth case impossible, in my opinion. Thanks for your 5. Lawyer's daughter says drainage equals bull and transfer seems illogical due to Chris Melton's timeline and degradation. Wouldn't most recent be most prevalent? Braves for Faust. I don't know. I'm not a DNA expert. And so I don't know if you can tell from a sample how long the DNA was there, but I guess they can tell how long it would be there. But I don't know if when you test a sample, you can tell how old the sample is, if that makes sense. You guys can correct me. I know there's DNA experts in the chat. Thanks for your super chat. AB says, I have a feeling prosecution will misstate evidence in closing to bolster their case, and I hope if they do, that it's objected to by Cruz. Cher became a member, and Cherry from Texas became a member. Welcome, you guys. Elemento G says, let's all light a candle when the jury gets this case until they come back with a verdict. Let's show our support for E and his family not guilty. Thank you, Elemento G, for your 10. J.R. Cuber says, good morning, Melanie. As a mother, grandmother, I'm so proud of Mr. Cruz. Thank you for all you do. You're the best. No, you are. You guys are the best because you care about this stuff and you watch it. Zoe says, no, Melinda, thanks for becoming a member. Division Bell says, exception if the defense introduces no evidence, the order may shift to give the defense the last word. That's interesting. And if that's the case, well, wait, it's the rules say, oh, so the defense would go first, then the state, then the defense could do a rebuttal. Oh, that's interesting. Then that could totally be strategic. They want the jury to hear their words last. That is interesting. Thanks for your 5. Polly Pockets Power Trip says, they lost evidence, mixed up swabs. He should have never been indicted. No ham sandwich here. Oh, DB, that's pretty funny. All right, we'll show this. All right. Somebody just sent this to me. Oh, wait. This is a video that DB posted. Watch the bailiff in the back. Hold on, we're going to flip to this for a second. Thanks, Tiff, for sending this to me. This is from, I don't know what day this is from because I don't remember seeing this. Watch this. This is from I don't even know what day, but let's watch the bailiff right here behind the judge, okay?
And I don't even see him this morning, but I put
doing
him on
eye
the email
drops.
too, so I thought he would communicate with the court.
Putting eye drops in behind the judge. In camera. In front of the on camera.
All right, thank you. All right, are you ready to proceed, Mr. Cruz? And I don't even
I mean, did you see that? Watch again. If you can come to your screen, come to your screen.
see him this morning, but I put him on the email too, so I thought he
Right
would
behind the
communicate with the court.
judge.
Okay.
I mean, thank
All
you,
right,
because
thank you.
sometimes we got to
All right, are you
laugh or
ready
we're
to
just
proceed,
going to
Mr. Cruz?
cry all the time.
And I don't even see him this morning, but I put him on the email too, so I thought he would communicate with the court.
That was from this morning? Oh, yeah, I guess that was from this morning. Because that's when she said, well, I can't believe you didn't contact me, even though your wife had been rushed to the hospital the day before, and I'm fully on notice of that. So it appears that if the defense does not put on evidence in Georgia, then they do get to close first and then rebut. So it's interesting. They should do maybe they should do like a coin flip or something. And we're still waiting for the charge conference. Low Mama 4 says that just occurred to me. He got into a fight with non-fatal stabbing 2 weeks later. Why didn't they investigate him then? The description of the black man didn't match Faust back then. Nothing to tie him to it. I mean, I looked at the sketches. I mean, do they look like him? If I can find them, we'll pull them up again. Do we know if Chris is in the courtroom? I do not know. I will ask. Music in My Soul says, oh, wow, I'm just getting here. Melanie, do you think you would have put a defense case if you were in Cruz's shoes? I'm not a criminal defense attorney. I'm not a criminal defense attorney. I think it was a good strategy on his part. So I can't say what I would have done, but it's a bold strategy, but they get to close first and last if that happens and they don't put on a case. What kind of witness could they have put on? If you're just getting here, then you didn't hear the pretrial rulings that happened this morning. Before today's trial, I should say. And he was hamstrung on a couple of things that he wanted to bring in and witnesses that he wanted to testify. And so he just made the decision not to do it. Thanks for your 5. Well, Chris is still under subpoena, so he can't be in the courtroom. He's not under subpoena anymore because evidence is closed. The evidence is closed. The state, both sides have rested, so he could come into the courtroom for closings if he wanted to. Cher says, hey, Mel, new member here. Hi. However, I followed you for a while now. What about the stolen laptop? No one saw the supposed black male walking with anything, right? Right. I'm sure he'll mention that in his closing too. Where's that laptop? People who have followed this case for a long time know that one of the original suspects was a lawyer who worked at that law firm that Tara had worked at. And that they had like a dinner within a couple of nights before her murder. Was it something she was working on? Was it something in the laptop? And then that lawyer like disappeared. And that is true. That's a great point. And I hope he brings it up in closing. And thank you for your super chat and for watching. Lone Star State says, if it's a hung jury, would they try again? I mean, I can't speak for them. Not guilty is my vote. But I imagine they probably would to justify the $5 million that they spent for the Coleman-Baker Act. And also, the district attorney doesn't like to have egg on his face. Hi, Ellie. Defense Diaries is here. Why reasonable to argue that the vaginal swab was mislabeled when oral swabs were marked A and B, since when is a presumptive test admission to support such a claim? Been screaming at the TV for days on various issues. I know. And somebody has pointed out to me that you guys did a whole show or a whole rant about true allele testing, because that was the other testing that I was bringing about.
On the record.
Thanks, Allie, for your 20. Love you. Talk soon.
Start from page 1. So, what I'd like. Did we lose Mr. Yamamoto?
I'm handling it.
You're handling it. Okay, very good. Then we'll continue. Yes. Okay. I will. Yeah. Okay. So, Mr. Cruz and Mr. Hill, I don't know if Mr. Bolden has been with us in a charge conference or not, but Mr. Bolden as well. I just can't remember. What I ask you all to do is just go page by page. So what we'll do is, and I'm going to pull out the indictment and go through page 1 by myself. What Ms. Ellis has done, of course, is consolidate everybody's charges. And it will, of course, eventually be a document that doesn't have the titles of the charges. Obviously, it'll read like just a regular document, but for our purposes, the titles will be in there. So if you all take a look at page 1, I'm going to look through the indictment and make sure it mimics the indictment exactly. But if you see any, this is the time, the first couple of pages, to see if there are any typos. That's, you know, just make sure we follow. And if there's a typo in the indictment, it goes into the charges as the indictment reads. We don't obviously correct anything. I don't know if there is. I'm just saying that's how we do it. So if you'll take a look at page 1 and let me know if there are any objections to page 1. All right.
No objections to page 1 from the defense.
All right. Very good. Let's do the same, obviously, with page 2.
State has no objection to page 2.
All right. You can certainly go on to page 3 and go through the indictment part of it. And just let me know what you, but I'll wait to, of course, hear from both sides.
There is what appears to be a typo on page 3.
Okay. Well, let me hear from this defense about page 2, and then we'll go to page 3. No, I mean, you can continue looking. I want to go in order in terms of any objections. So I'll wait to hear from Mr. Cruz. There's one. Okay. Okay. Got it. All right. Thank you. If you all go to page 3, and Mr. Goldman already has a comment, go ahead.
It's okay if I just stay.
Yes, you can all stay seated. Yes. Yes, of course.
So in count 7 of 12, for the said accused in the county of Clarke and state of Georgia, did perform a sex act with the person of Tara Baker involving the sex organ of and
What?
8 in front of.
Okay.
That's all.
All right.
At the bottom of page 3, after Edrick Faust, the word with the offensive rape.
Right. See it? Thank you. Anything else with regard to page 3?
I didn't.
All right. Mr. Hill, Mr. Cruz, are you okay with page 3 after the correction? And the word with. Okay, we'll go on page 4.
I'm trying to get a copy of these charges, but I can't because they're not part of the docket yet.
Top of page 4, the second line, it says January 2001 did have carnal knowledge of Tara Baker. However, in the indictment, oh, no, I'm mixing them up. Please forgive me. I missed them.
Okay.
Disregard that.
Okay.
Allie is continuing from defense diaries. Oh, and several innocent ways that there could be DNA in her mouth, transfer from public places, even air from crowded restaurant. DNA from 3 or more people is very unreliable. What about the fact, Allie, that Tara Baker's own DNA was not found on one of the oral swabs?
Page 4, Mr. Bolden, anything from the state about page 4?
No, Your Honor, and I've just gone all the way to
Okay.
the bottom of page 5 to get through.
Okay.
Thanks, Allie.
Okay.
I'm still on page 4.
That's fine. Absolutely fine. I just want you all to know page 6 in the very top, there's a typo. It needs to be his instead of her, but we'll get there. Those are the easy things to correct.
Cindy says, do you think he should have said, since I'm unable to present my case, the defense rests? I don't know if that's a rhetorical question or not, but no, I don't think he should have said that. Thanks for your 5. He would have probably been sanctioned again and forced to pay another $1,000, or maybe this time it'd be $2,500. Jaded for Justice, thanks for tuning in from Canada, says, so now Yama Bad Abadu can't be bothered to come for the charge conference. Oh, where is he? He's not there. The boring stuff is beneath him. By the way, happy birthday. Oh, thank you very much. I don't know. Maybe he had an emergency or a doctor's appointment. I have no idea where he is. Mermaid Mary says, I truly appreciate your coverage of cases like these and support of fierce legal advocates like Mr. Cruz. Your commentary is so valuable. Thank you. Thank you. Bonnie Mae says, happy belated birthday. Thanks for all your hard work and dealing with trolls. You're a gem. Oh, thanks. Thank you, Bonnie, for your 5. Lone Star State says, happy birthday. Thanks for making it fun going to trial with you every day. Oh, thank you very much for your 5. CC Zar says, can we just have Allie up for a good old-fashioned ladies rant? I think the 2 of you together would be epic, please. Thank you very much. I don't know. Maybe we can. Thanks for your 5. Or what? I didn't see what it was. It was Canadian. Thank you for tuning in from Canada.
All right. No issues with count 4, Your Honor.
All right, page 4. We'll go to page 5.
It's very exciting charge conference, huh? Very exciting. Yeah, maybe we'll have Allie come on during verdict watch. If they're going to break until 2:30, I may start another stream for closings. That's what I may do. We'll see what happens here, how long this charge conference takes.
against you in count 12 of 5. Just the word on is missing. Word on or about the 19th day of January 2001.
All right. Let me just make sure that's what the. Okay, that's exactly right. Let's see. On, we're going to put an on before the or.
Right now, it's just pretty much grammatical errors. Allie, if you're still here, is there a new date on Aaron Spencer? And are you guys still going to go to the trial?
Also, count 12. The last line of count 12, well, the third line from last count 12, where it says laws of said state the good order in peach instead of peace.
You got it. Peach does not fit. Okay, excellent. Thank you. When you get to page 6, the very top should be his as opposed to her. So that's the first thing we need to change. When you're ready, if you all go through page 6, let me know what your position. Yeah. Okay, I just want to remind you all, Ms. Ells made a good point. Everybody's requests are in this document. We haven't taken anything out, state and defendant. So it's a big document. Obviously, we'll figure out how to pare it down properly, but just so you know, everything you've submitted is in here. Yeah, sure. Yep.
Yeah, Pat, her fingernail scraping or her fingernail clippings contained only her own DNA. Oh, maybe that's it, Caesar.
Just a hyphen in between not guilty.
Well, we typically have it in there. I'm not sure why we do, but if you would like us to take it out, we certainly can. All right, we'll do that. I think it just reads better, but we certainly can take it out.
Oh, Allie and Bob, there's somebody who's just gone to Block Island who thinks that we should be in jail, all of us. Oh, do you think John O'Keefe got hit by a car? Is that what your problem is? Or are you just looking for your 3 seconds of attention? Caesar says, do you think that the DA's out quickly writing his closing because Cruz surprised him with it by not presenting a defense case? Very possible. Very possible. He should have been prepared, but you never know. Thanks, Caesar, for tuning in from Canada. We should be in jail for having opinions that trolls don't like. Oh, aren't you sweet? Bless your heart. Bless your heart.
In the second paragraph of page 6,
Yes.
the 4th line, where it says defendant is guilty of the offense charge, or just change it to offenses.
I have to figure out where you are. Hang on just a moment.
paragraph. Well, the first full paragraph. First full paragraph. In the fourth line.
Well, I think we always have it as crime, just because I think it indicates that they have to individually apply this reasoning to every single charge. And so I see what you're saying, but I think we're going to leave it in there just because I don't want them to misconstrue that they have a responsibility that's not individual to each charge. Yep.
Spencer is going to, you guys are going to the trial, Allie says, and the unofficial date is likely mid-March. Okay. Okay. At least the weather will be a little bit better. Really sucked that you guys went all the way down there and then it had to turn right around before that blizzard.
There's no burden of proof upon the defendant. The word whatsoever is missing. And that is the second full paragraph, third line.
All right. Let me look at the pattern. I've taken this from my standard jury instructions, and I'm not sure I have that word in there. So we'll look at the pattern for burden of proof and see what it says. Certainly want to follow the pattern.
No nudes so far. Says the troll attacks have been wild lately. Yeah, you can always tell when the person just joined YouTube one day ago, just yesterday.
This is the pattern.
Waited 24 whole hours to come in.
That'll be the fourth paragraph of the pattern if you're using Westlaw.
You're right. It says whatsoever. There's no burden of proof upon the defendant whatsoever.
Why you have that pattern, Judge, is also.
Oh, as did another one who just joined one day ago. Enjoy your
And
trip
the
to Block
burden
Island.
never shifts to the defendant
Loser.
to prove.
Well, it says to prove innocence in the pattern. We have the word his, but we can take his out.
Well, no, that's not.
Okay.
It says, and the burden never shifts to the defendant to introduce evidence or to prove innocence.
All right. Mr. Bolden, any objection to increasing the language of the pattern charge and putting in introduce evidence and what? Introduce evidence or to prove innocence?
That is what the pattern says.
Okay.
Your Honor. Mr. Cruz wants that.
Yeah, no, I agree. And I think I'm going to change my patterns in the future to reflect that, since the pattern says that. They do change a lot of these patterns kind of every 6 months, and it may be that has been changed and I didn't realize it. So we're going to add this to paragraph 2. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. And I'm going to keep the word his in there unless you don't want me to, Mr. Cruz. All right.
Max says it must be recess at the Troll Middle School. Well, yeah, they all only joined YouTube yesterday. I had it set to 48 hours. But then Jessica couldn't chat, but I don't even know if Jessica's still here. So I'm switching it back to 48 hours. I'm done with their 24-hour-old trolls. They're so patient, if nothing else. Your tenacity is so admirable. The way you attack children is so admirable. Oh, so Allie, you're using the Defense Diaries account right now. Cool. There are no subtitles because it is live, and when it is live, there are no subtitles.
Can we copy the pattern language when we get into the definition of reasonable doubt?
Tell me what you mean.
Verbatim?
Hang on one second.
Tell me
I
what
just
you
need to
mean.
send this message to another attorney about a case from Monday. So hang on just a moment. Okay, go ahead, Mr. Cruz.
Pattern language, and it's not a big.
Tell me where you are. Tell me.
I am on the 5th paragraph of the pattern charge, starting with sentence 2.
On what page?
Page 6 of the.
Okay, hold on. All right, you're asking about the reasonable doubt pattern?
And page 6 is the last paragraph. So the pattern charge. I apologize. The pattern charge states a reasonable doubt means just what it says. I believe that matches. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. And I believe Your Honor has the pattern charge up. Yeah, can we just use the exact language of the pattern charge?
Well, we have all of this in here. I guess, is it just because it's in a different order?
Yes, ma'am.
We need to start with the burden of proof.
Belinda says Ballard's on Block Island has a 2-for-1 troll special day. It's a view. A view is a view.
Well, we have, I mean, it is in here exactly the same. It's just in different paragraphs. I think
So the
it is exactly the same.
okay. So we're
So it's the pattern as written is reflected in the charges. I think maybe the difference is the statement, however, the state is not required to prove the guilt of the accused beyond all doubt and true mathematical certainty is in the paragraph above it.
no, that's fine.
We can move that to the paragraph below as it is in the pattern, but the order in which those phrases are or those sentences are done is exactly here. It's this. I think it just looks different, but I can move that sentence, however, to the next paragraph if you'd like.
So the difference I have in mind is the pattern charge, and I think generally it says the same thing, but we're really big on language, and I'm very careful on language. In closing, it says it is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. And it says essentially the same thing, but the pattern charge says a reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth.
Repeat the words a reasonable doubt. Yep. I think that makes sense.
And the I ask this, if it's not too much, can we just copy and paste that paragraph from the pattern charge and stick it into the charges?
Well, it is the same with the exception of what you just presented and the fact that however, the state is not required is actually part of that paragraph in the pattern. In our documents, it's part of the paragraph above it. But
And that's no issue. That's no issue.
But the rest of it, I think, is exactly the same, except for the words "a reasonable doubt," mentioning it again, which I will do. But I want to just make sure that put down again a reasonable doubt on the second line.
Every state has its own pattern jury instructions that are used as a sort of
So this is how it's going to read. This is
model.
what the pattern says. However, the state is not required to prove the guilt of the accused beyond all doubt or to mathematical certainty. We can put that down to the next paragraph and just make it one paragraph. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt, and the rest of it is the same. Does that satisfy you, Mr. Cruz?
Yes, ma'am.
Okay, that's exactly what the pattern says. All right, and anything else on page 6?
On the last,
Golden, if you want to jump in there while we're having this conversation, obviously do that.
Of course, Your Honor. State has no position.
Okay, all right.
The pattern jury instruction is a template, and it's and they can be tailored specifically for each case, and sometimes they must be.
Okay, yep.
Yeah, Written Dreams pointing out Brian Albert's former workmate is being indicted for perjury. So yeah, they're pretty uptight right
When
about
you're
now.
ready to go to page 7 and let me know what you think about page 7.
I included grave suspicion of guilt.
I'm sorry? Yeah, we haven't gotten there yet.
Okay, got you.
Yep. What you all are reading that goes through top of page 10 are the standard patterns that all superior courts here at least have in their arsenal. And obviously these are ones you all have asked for, but it's our standard ones. And so we haven't gotten to the specific ones you've. Yep. Yeah. So everything you all have asked for, we haven't kind of gotten to that yet. I mean, the specifics.
Yes, 100%, Paola. I think he's written his closing already for sure. Got to be ready. Always got to be ready. Ashton, I think the trolls just want to disagree with whatever my opinion is. They will take automatically the other position just because that's how much they hate me. Because that's how much they know that what I have to say is people listen. There's a lot of people watching. So, you know, no matter what my position is on anything, they automatically take the other position and they try to twist themselves into a pretzel because John O'Keefe was not hit by a car and a car did not hit John O'Keefe. And there was no statute of limitations on murder. So indictments on the murder of John O'Keefe could come down at any time. I mean, it's crazy how that works, right? Thank you, Robin, for gifting 5 memberships. You're amazing. Sarah Be Creative thinks the judge should be a referent, the NFL. Thanks, Sarah.
All right. With the jury instruction, jury judges of law and fact,
Which page are you on, Mr. Cruz?
7.
Okay.
Just the last sentence says, it then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts. Okay. It's nothing that needs to be changed. Attention.
Yeah, those are the easy things to correct. You know, it's not easy to correct. This sham prosecution, the fact that it was even brought in the first place. Strong legs. The trolls don't have regular jobs. Some of them are just regular moms. You know what? I would do that, Lisa, except the Grammys are so trigger happy on copyright issues. But she says you should use the video of Cardi B award speech for Best New Artist in 2018, where she thanked her haters for downloading music and making her more popular. Anytime you get a troll, I know it's great. It's Friday the 13th. Maybe they know their luck is about to run out. The defense did not put on a case, so the defense rested first thing this morning. The charge conference is jury instructions. So it's exactly what it is, Patty. When they say charge conference, it is how, what are we going to charge the jury? And so that's exactly what they're discussing right now is jury instructions, but we don't have a copy. But as I said, every state has its own pattern jury instructions. You can find them by just Googling Georgia criminal pattern jury instructions, and you can get your own little booklet and see exactly what the standard jury instructions are for each thing they're talking about, like reasonable doubt. Usually in a case like this, they would talk about inferences that cannot be made from the defendant's choice not to testify. The difference between direct and circumstantial evidence. The credibility of witnesses. Expert witnesses.
All right, are you all still on page 7 or we moved on to page 8?
I am, Your Honor. I'm
All
looking.
right, okay. Mr. Bolden, are you still on page 7? Okay. You okay with page 7?
Yes.
Okay. Sorry. Nope, that's fine.
Reasonable doubt and what reasonable doubt is. They always talk about the definition of the charges. What is felony murder? What is malice murder? They're going to have to talk about the definition of burglary because he's charged with burglary, and definitions of sodomy, and rape. No, they're at the state level. That's a good question. Jury instructions are at the state level, not the county level. Oh, Ashley says, I think we may see some of those other set indictments around November-ish of 2026. Thanks, Grammy, for becoming a new member. And Zay, thank you for gifting 5 memberships. You're amazing. Thank you, Peachy Tree, for becoming a new member.
All right. No other objections. Page 7, if I'm
All
not
right,
kidding.
we'll move to page 8.
Law Mama 4 says, yeah, this case is 25 years old. So whomever killed John, or covered it up, I would add, We'll never be able to relax now. The trolls will keep yelling at me. That's right. You're right. You're right. Oh, the new thing they're trolling me about is they're saying that they can't find any evidence. Wait, hold on.
What's the site? The site for evidence is the means by which any facts which are put into issue is established or disproved. Do you know the site for that one?
You mean the pattern number?
Yes, ma'am.
Well, it's really hard to look them up.
I think
Is it really hard to look them up? Because I have a book right in front of me.
1.3010. I think I just found
Got
it.
it right here. Yes, what about it, Mr. Cruz?
Is that it? No, I just wanted to find it. That was it.
Okay.
Just to match it up.
The instructions that we have that we use don't make it easy to like search. We do it in order, but it doesn't make it easy. This is a proposition.
1.3010 reads evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved.
Pattern does read that evidence includes all of the testimony of the witnesses, parenthetical, and any exhibits submitted during the trial. And then the next parenthetical says stipulations of the attorneys, which I think would be applicable here because we do have the one stipulation as to the photo of Mr. Faust that was that. So the photo was entered into evidence, but then the stipulation was also that it was a photo taken of him on, I think it was February 8th of 2001. Mr. Yalamanchili put that on the record at the time that the photo was tendered.
Okay, so you're saying this is the pattern. Evidence includes all of the testimony of the witnesses and then parentheses, which I don't think is applicable.
Correct.
The equivalent, such as depositions, so we'll leave that out. And any exhibits admitted during the top trial, stipulations of the attorneys, that is any, okay, so do you, I could, well, and I'll hear from you, Mr. Cruz, I could just do it this way. With all the testimony of the witnesses and any exhibits admitting during the trial and any stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, period.
That would be this, how the state would ask that the court.
Mr. Cruz, how do you feel about?
I have no objection to that, Your
Okay,
Honor.
so we'll do it that way. Oh, no, okay, hold on. I have your computer. How could you have gotten? All right, so what we'll do is input the word and any stipulations that the attorneys put that all in there, and then not matters of judicial.
Bon voyage, says Mystical Beowulf. Bon voyage, trolls. Bon voyage. Karen says, I have to say Chris's testimony was the wildest
I would
I've
also
seen.
say, I don't know if this was in the requests that I made this morning, and if not, I apologize, but I think that does make the next one in the pattern, which is 1.30.12 applicable, which is the pattern on stipulations.
All right, we're gonna look it up in just a minute.
I apologize.
Well, I mean, this is what this is for.
Sure.
We have to, you can also make oral motions for certain charges. I mean, that's obviously why we're here. So let me let her finish 1.30.10 and then we'll. Might have added to this case specific one. So if it is added in, we should put it there. That would make sense.
Yes. I apologize.
It was?
It was not.
It was not.
So it would not be in there.
Okay, so I think, okay, 1 point, okay, so Mr. Cruz, in case you don't have it in front of you, 1.30, Point 12 says,
1.30.12 is about stipulations. Thank you, Karen. She says, I have to say Chris's testimony was the wildest I've ever seen, especially when he got whipped out of his trance.
okay, I was trying to figure out where it was. So there are several, let's all look at 1.30.12. There are several things that could be I'm just going to throw out what I think, and then I'm going to listen to what both of you want to add. There's only been one stipulation, and I think making a providing all this emphasis would be very confusing to the jury. This would be my sense, but I'll hear from both of you, to just put in there, the parties have entered into a stipulation that has been approved by the court about however we decide it is about the picture, and leave it at that. The rest of the statute is pretty convoluted about probably convoluted stipulations. And so that would be sort of my.
And that would also be the state's position and request, Your Honor. So again, under that pattern charge, 1.30.12, just that the parties have entered into a stipulation that has been approved by the court about the following exhibit, whatever exhibit number that would be, and then that was a photograph taken of the defendant on February the 8th of 2001.
I think you both have to come up with the language that suits you both before we get into that.
Sure, I apologize.
Sure. No, I mean, you don't I have to apologize. I mean, I just think we need to talk about what the language is. Mr. Cruz, without getting into what language is the exhibit that's been that describes the exhibit that's been stipulated to, do you have any objection to 130.12, which is the parties have entered into a stipulation that has been approved by the court about the following exhibit?
I do not.
Okay, so let's talk about, so we'll put that in there. Let's talk about how to phrase it. Let me get us. You say again, Mr. Bolden, what you think it should say?
Yes, Your Honor, I would say that, so the parties have entered into a stipulation that has been approved by the court about the following exhibit. And then in the pattern where it says specify, I would suggest something to the effect of that state's exhibit, whatever the number is, and I'll find that out momentarily, was a photograph of the defendant as he existed on February the 8th, 2001.
Okay. Cruz, thoughts on that language?
That's what we agreed to.
That's what I thought. So I hope.
Are you satisfied with that, Mr. Cruz? Okay. Will you say it slowly so Ms. Ellis can take that in?
I will. I probably won't be able to do it exactly the same way, but I will try. That state's exhibit blank, which I can fill in due course, is a photograph of the defendant as he existed on February 8th, 2001.
Okay.
That's cool.
I have 113. I have that as a stipulation, but I didn't label in my notes what the stipulation was. So we need to double check and make sure it's 113. We can do that when we're finished, but let's make sure we actually get that in there. Okay. Let's keep going on page 8. Okay. I'm going to read this to you all since Ms. Ellis has just redone what you have said. The parties have entered into a stipulation that has been approved by the court about the following state's exhibit 113 about I think we should just say about State's Exhibit 113. I'm going to just say about the State's Exhibit 113, unless you all have, it just sounds better. About State's Exhibit 113, a photograph of defendant as he existed on February 8th, 2001, where parties stipulate, let's see.
Yeah, his mugshot from that other
Where
charge.
parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. That is the pattern. Mr. Bulger, I'll ask you first. Any thoughts on all of that?
That's acceptable to
Okay.
the state, Your Honor.
Mr.
Thank you.
Cruz? All right, we'll move on to page 9.
Yeah, that exhibit was his mugshot from 2 weeks after Tara's murder on a different case where he got into a bar fight with a guy. And Caroline, one of our viewers, says that her father was his attorney for that and got him off for something like time served and probation. Here's a shout out to Defense Diaries podcast, buried inside the John Wayne Gacy investigation. It's fire. It says everyone who's listened to it, so go listen to it. In case you don't know, Allie's husband Bob, his father, defended John Wayne Gacy back in the day. Notorious serial killer. Yes, Georgia judges are elected. Did I just highlight a comment earlier? Is she up for re-election? Judge's name is Lisa. Lisa Lott, L-O-T-T. A lot of good reviews here for Buried Podcast by Defense Diaries. Watch Josh, she says, one of the best I've ever listened to. Definitely recommend it. It's become my #1 true crime podcast ever. Ever. Oh, wait, there's eye drop bailiff. Hold on. Let's see what if he's going to do anything. Now we need to watch him.
Your Honor, on page 9, at the very, not at the very bottom, but towards the bottom, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. I see that that's the 1.31.45. I guess the state's concern here is I am not certain that anything has been disproven as to what they testified to. I understand that the defense would maybe disagree with whether or not their credibility, and that's a separate instruction. So the kind of that particular pattern gives an either or. The first part says impeaching a witness is to show that the witness is unworthy of belief. Then there's the or. the credibility of a witness may be attacked by disproving the facts to which the witness testified. I mean, it's my position, state's position, that that second part would actually be more tailored to this case.
The whole okay, so you want to go to page 21.
My page.
Okay, hold on. Let's fast forward to the
Defense requested it.
okay, the
Defense number 11.
defense number 11. Let's go to defense number 11 and look at the whole pattern in total, and then we'll discuss it. Since what we did was we included everybody's requests and didn't take them out, even if they touched on something ahead of time. So on page 21 in the middle is defense request 11, which is the pattern. All right, Mr. Cruz, do you care to be heard? Which of those portions of the pattern you think we need to have?
I believe the first one. I think a big, well, 21 is large. So let me start there. Well, where we starting on page 21?
It's the one right in the middle, 13145.
Okay.
You're 11.
So I would say to impeach a witness is to show what Mr. Bowden read into the record.
Yep.
Witnesses impeached each other during this trial. We use certain witnesses to impeach other witnesses. I think a big one that sticks out vividly is, I believe Ricketts was extremely adamant that Chris Melton's alibi had been confirmed. And we went through with other witnesses establishing that it had not, in fact, been confirmed. And I think a big part of our cross was locking Ricketts deeper and deeper into his statement that we confirmed it. And I even think a little bit with Ricketts, we started going with him through some of the places that were unconfirmed that he ended up admitting. So and that's just one example here. And I think a second example was Mr. Melton, who refused to acknowledge that he was living in his parents' basement at the time. And obviously because we showed him the photos with the doors showing how he could get out. However, Josh McCourty was the witness that came in right behind him and said, oh, Chris was staying in his parents' basement. So we would ask for that instruction. We intended to use it in closing.
How would you both feel if the court included both of them in the manner in which it is in the pattern, which is disproving the facts to which the witness testified, or let's see. I don't know, including both of them. I'll have to think about how to do that.
I don't have any objection to including.
I don't want it to be confusing, but Mr. Bolden.
I mean, I guess it is, but my point is still that I don't know that that's actually disproving anything that another witness testified to. I understand Mr. Cruz's position, but I think Agent Ricketts' opinion that Mr. Melton's alibi was confirmed is like that's getting into kind of a subjective nature of his assessment of the alibi, and you can't disprove something that is a subjective belief in someone's mind. If it was an objective fact,
False memory.
I think that's really more what the impeachment statute and the impeachment pattern is designed to cover. Again, I think that it will all be covered in, credibility and stuff like that. And that's the only reason I bring that up.
Well, I'm not going to make any comment on the evidence.
Sure.
The strength of the evidence. That's for the jury to decide if they choose to about these particular moments we've been discussing. So I think it would be appropriate to include the entire pattern as written. And I think I'm going to do that. I'm going to grant your request, Mr. Cruz, and have, let's see, I think we need to put it, defense's request 11 in, on page 9.
Question for you. On the bottom of page 9, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony. Where is that located, the pattern number?
I don't know exactly. I mean, those are our standard charges that we have from pattern. And I always read those, and I'm going to continue to read those. But I will find the pattern for you. But let's just jump on top of it.
I see that one.
Yeah, let's jump to the impeachment first and get that squared away.
Yes, ma'am.
So we're going to keep in defendants 11, defenses 11, and it's going to read, let's see, exactly how it is. It's going to read exactly how it is in the, as you've requested, it's already in the instructions. But let's talk about credibility of witness. Let's see.
You know, it's like so easy to just,
I'm just going to put in there, and I'm doing this over objection by the state. This is how it's going to read. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I'm just going to put both of them in there. I know the pattern says or. I don't think it'll be confusing. I don't want to comment on the evidence. I'm just going to put the whole thing in there. So we'll put it in that area on page 9 where it starts with to impeach a witness. Does that make sense? Okay. All right. Let's go to then the next paragraph. You had a question about that, Mr. Cruz?
I did not. I found it. I was just
Okay.
trying to match
All
it
right.
up.
Anything else about page 9 from the state of the defense?
No, ma'am.
Let's go to page 10. And then page 10, right after the very first paragraph, is where we start to put in the requested charges.
a good way to not get blocked on this channel is just to not be a dick. So
Yes, and
court's
we're- sorry,
indulgence,
Ms. Ellis
you're a
wanted me to make
dick.
sure everyone knows,
gone.
we obviously pull the titles out. I don't put the pattern number in there. I don't know if some courts do that, but we don't. It just reads like a document. The whole thing reads smoothly like a document.
Yes, ma'am.
Court's indulgence apparently hates Ahmad Cruz, hates, because the only time you've ever been in this chat ever is today, and thinks that Ahmad Cruz is lying about his wife being rushed to the hospital. Lying. And writes, because, you know, you needed your 3 seconds of fame, wrote his closing yesterday when his wife was alleged, and Biss, wrote Biss closing yesterday when Biss' wife allegedly was, quote, rushed to the hospital. You're a dick. You're gone. Enjoy Block Island. It's really lovely this time of year. I wish you luck in life. And I wish that you have the day that you deserve. You will be
Mr. Bolden,
called
I
out.
wanted to ask you on page
will.
10, after 1, 2, and 3, where there are 3 phrases in parentheses, are you asking for all 3 phrases to be in there?
I'm sorry, can you say that one more time?
Yeah, that's, well, you have to be looking at the page to understand what I'm saying. It didn't make sense. Sorry.
No, that's all right.
Okay, so after 2, 10, 10,
Yes.
put in your request 1, defense's request 35. Oh, I should ask you this too, Mr. Cruz. I actually just saw that it was also your request. All right, both counsel. With regard to 2, 10, 10, after where it says for malice murder, the state must prove the defendant 1, 2, and 3. The next paragraph, at the end of that paragraph, has 3 parentheses. Without justification, another one without excuse, another one without mitigation. I'm asking both counsel, do you want all 3 parentheses in there?
We can. I don't think it's applicable to this case. I think we may have filed a motion, I believe, letting the jury know that identity is the issue. We may even say it in closing that the sole issue is identity. But it's up to the honorable court. I have no position whether the honorable court includes it or.
right.
Well, I guess it does, Nick, because it is the law. I think that is in the statute, if I'm not mistaken. So yeah, I think it would need to be included unless a particular one applies. And in this case, no one's arguing a particular one applies.
Yes, and I would ask that there be a period after the word kill. I'm not asking for any of the parentheticals. I don't think any of them are applicable.
So you're just asking rather it is the unlawful intent to kill, period, without the parentheticals. That's what you're saying?
Yes.
Okay. Mr. Cruz, any objection to that?
For purposes of the record, I would say yes.
Okay.
I would just say to keep it with the statutory language. I don't disagree with Mr. Bolden in substance, but I do have to be aware of the appellate record here. So I would say
Okay.
without justification, without excuse, without mitigation, but I'll leave it to the honorable court's discretion.
I think I am going to, I'm going to take it out. And the reason I'm going to do it is this. There hasn't been any evidence regarding justification, excuse, or mitigation. And so I think it would be confusing to the jury. And obviously, that's one of the most important things to look at when you're dealing with charges. It also doesn't fit the evidence. And so I'm just going to put a period after the word kill. All right. And then the next two paragraphs is part of that pattern, of course. You both have asked for it, but if there's something you're thinking about you want differently, let me know.
Thank you, Love Son, for your super sticker. I appreciate you so.
And the honorable court's ruling is supported by the pattern charge. It says charge only the appropriate language, adapt parentheticals to the indictment and the evidence.
Gender Neutral wants to know if guilty verdict, good arguments for appeal. There are a few. Thanks for your deuce.
Your Honor, I've moved on to page 11.
Me as well.
All right, very good.
So I don't have any issue with premeditation, which we both requested. As far as motive goes, I mean, I requested it and we just copied straight from the pattern. State does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining if the defendant's state of mind at the time.
There's been no evidence of motive.
State hasn't offered any evidence of motive, so I don't know that the second sentence is applicable here.
Let's talk about, before we do that, the 21011 that you both asked for, premeditation. Any objection to how it's written in the charges?
And I'm matching it up there. If you give me 30 seconds, Your Honor.
Sure.
We might be a scooch behind. Let me see.
In the 21011, do you have any objection? You both requested it. Any objection to how it's written?
No, ma'am.
Okay, so we'll move on then to 21012, motive. The state has, you've both requested it. The state has asked to get rid of the second sentence. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Any comment on that, Mr. Cruz?
Well, I intended to use motive in our closing. And that sentence, although it says defendant, I was going to switch it to fit our evidence in this case. I would ask that it's included if any change is made. Defendant is fine with me, but if the honorable court wants to make any change, just defendant is fine. Defendant is fine with me.
I'm not making any comment on your closing at all.
He's probably going to argue that Chris Melton had motive. See?
But I am going to get rid of that sentence because I don't think it fits the evidence with regard to
To the defendant.
the state's position
That's fair.
of evidence of motive for the defendant.
Yes, ma'am.
But certainly you've made it clear you've talked about motive for other things, and you're certainly not prohibited from talking about that in your closing.
Thank you,
So
Jersey
it'll
Queen.
just read 21012. We'll read the state does not have to prove motive to prove murder. All right. The next one that you have both requested is felony murder. And we need to talk about how to articulate that. There are 4 counts, I believe, of that in the indictment. Count 2, 3, 4, and 5.
For felony murder, the state must prove that the defendant, 1, caused the death
So
of
let's
another
just talk about
person,
21020. Any objection to how it is written?
and 2, by committing a felony. That is 21020. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony.
And it's obviously the bottom.
No, not how it's written, Your Honor.
I'm sorry?
No.
Okay. Mr. Bolden, any objection to how it's written?
No, Your Honor.
All right, let's talk about how to talk about blank is a felony, which I will define for you shortly.
Thank you, Jersey Queen, for gifting 5 memberships. You're
Yes.
amazing.
We're going to take the parentheses off where it says the state does not have to show that the defendant acted with malice to prove felony murder. Just leave it as a sentence. The next one is blank is a felony, which I will define for you shortly.
Can we, oh, I'm sorry. I
Yeah,
didn't mean-
go ahead. No, go ahead.
In regards to that, can we state all, I think it's 4 felonies. Can we state all 4 felonies? So rape, just state them back to back. And then when we move to 21030, we can say the same thing with the first blank with all of them, regardless of whether he or she. And then when we get into the definitions, if the state doesn't disagree, just to keep it from being confusing, we discuss each charge just back to back to back. So that way we note all 4 felony murders. We note all 4 underlying charges. And then we also note or give the definitions following. So we at least signal to the jury, there's 4, and here are the 4 and the definition of the 4. And it may kill 2 birds with one stone because it also gives them the definition of the underlying crimes as well that we were charged with.
I think there may be some agreement, Judge. What?
Tell me what you mean. I mean, whatever way it needs to read where it doesn't confuse people is fine with me. I just want to.
What in the way that I submitted it in the state's requests is where there's the blank at the bottom of page 11 would just be burglary, aggravated sodomy, rape, and aggravated assault are felonies,
Okay.
which I will define for you shortly. And I think that's
Okay.
what Mr. Cruz is saying as well done.
Is that what you're saying? Just
That is.
all in one are felonies, which
Right.
I will define for you shortly.
Right.
Okay. Okay, so it's burglary. Do you want it to say burglary to a dwelling or just burglary?
This is why he's charged with 4 counts of felony murder. Because the definition of felony murder is that the defendant caused the death of another person by committing a felony. They're alleging that he committed 4 felonies: aggravated assault, sodomy, grape, and burglary. That's why there are 4 charges for felony murder, because each one of those felonies entitles the defendant to a separate charge of felony murder. Okay, here we go.
Burglary would be.
The indictment says burglary to a dwelling.
So we'll use the indictment language.
All right, so we'll do burglary to a dwelling, comma, and we're on 21020. Burglary to a dwelling, comma,
The guy never went in the house.
aggravated sodomy, comma,
Well done.
rape, comma, and aggravated assault. Assault are felonies, which I will define for you shortly. Counsel, are we in agreement on that?
Yes, Your Honor.
Okay. Let's go to the next. Yeah, of course. You're the one doing this.
In the very beginning,
Mhm.
the grand jury has indicted the defendant with malice murder, felony murder, felony. I had just written burglary, should I put burglary to a dwelling?
Well, I guess the difference is that count 2 says burglary to a dwelling in reference to felony murder, but the count 6 says the offense of burglary. So I think it probably reads, that's accurate, yeah. Okay, let's do 21030, causation and felony murder. Both parties have requested this one.
A lot of people are asking, how is it burglary if no evidence anyone broke in? Well, that's up to the jury. If the jury decides there was no burglary, they would find him not guilty of the felony murder charge that includes the burglary. You see? The judge didn't direct a verdict on that because she thought there was some evidence, perhaps the screen. Etc. They tried to have it dismissed. She didn't go for it.
And it goes from 11 to 12.
I have no objections to that one, Your Honor.
And so again, kind of just like a minute ago, I think what the state would request is that you may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary, aggravated sodomy, burglary to a dwelling, aggravated sodomy, rape, or aggravated assault. Kind of to track the language that we just talked about.
Any objection to the way that that's been articulated, Mr. Cruz?
No, ma'am.
Okay, we'll use the word or, regardless of whether he, not she. Okay. Any other comments about the top of page 12, which for our purposes is 21030? Any more comments on that?
No, Your Honor.
Okay, Mr. Cruz, are you satisfied with 21030?
Yes, ma'am.
Okay, let's go to 26221, burglary in the first degree. Both parties have requested it. Mr. Bolton, let me ask you first, since it's your burden. Number one, did you want both entered and remained in? One.
I was just looking at that, Your Honor. I think that's the way. Oh, where are you? I would ask that it have both entered and remained in, because those are both included in the charging language of count 6.
I would have.
Here's the statute. Burglary in the first degree with intent to commit a felony. For burglary in the first degree, the state must prove that the defendant, 1, and you have a choice of entered or remained in the dwelling of someone else, 2, without authority, and 3, with intent to commit a felony. So the court has the discretion, or the attorneys can argue about whether the state must prove that the defendant entered in the dwelling of someone else or remained in the dwelling of someone else. Looks like there's a choice here in Georgia because there's parentheses around both of them.
Because you all's theory, I guess, that he entered the house and.
Okay, it does, count 6 does say enter into and remain. That does track the indictment.
So the indictment has both.
I think it needs to say entered into and remained to track the language of the indictment.
But that doesn't mean the indictment is
Mr.
correct
Cruz,
if the jury instructions offer a choice. But that's the way they charged it, so let's see.
Do you have any objection to that change on the number 1? Okay, so we'll do that and get rid of the parentheses. Do you have that, Mandy? We good? Okay. The intent to commit a felony. All right, let's go to count 2. And then we put in here well, I'm okay. Mr. Bolden, what are you asking the court to put in the blank?
In the blank, I would say aggravated sodomy and rape are felonies, which I will define for you shortly, because those are the specific felonies that are referenced in count 6.
Okay. Any objection to that language?
No, ma'am.
Okay. Let's go to the bottom of that pattern that you both have requested, and let me know what you think.
Well, I guess we'll wait till we get to it.
I'm good through the bottom of page 12.
I am too.
Okay. All right. So we're going to start on the next one. I'm going to just make sure Ms. Ellis can follow with us. It's 26223, intent to commit a felony. right, this is state's request 7.
Yes, Your Honor.
All
And
right, what is your request?
Your Honor, bear with me just a second.
Okay. Okay. All right.
And on our copies that you provide us, it will have the title on our copies. Oh, it won't have any title.
No, this is the only version where you'll have the titles. So what we're going to do is Miss Ellis is the master at all this. She's taking down all of our changes. She's going to incorporate it in the master document and delete, of course, all of the titles. And then what I do is I make a copy for every juror and every attorney and Mr. Faust. So everybody will have their own copy, and it'll be the same that the jury is holding.
Okay.
I would, Your Honor, I think I would withdraw state's request number 7.
Okay. We're going to withdraw 26223. Yes. Okay. All right. We could email it to all of you when we're finished. Sure. All right. So let's, we'll get rid of that. All right. 26231. This is state's request 8.
We would ask that that be given.
All right. We're going to have to,
But I would, my suggestion as it relates to state's request number 8, 26231, would be to move that to until after the court defines burglary, which I think is later.
can we just do this? We just
262,
define burglary.
Okay, I'm sorry. Okay, I'm sorry.
26231 is the meaning of entry. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This breaking of the plane, plane, must be done by 1, the defendant, 2, any part of his or her body, or 3, any instrument controlled by him or her. The state does not have to show that there was an actual break-in to prove burglary.
Yes.
Okay, so I guess my question is, how did you want 1, 2, and 3 of your request to read before we get to Mr. Cruz's response? Or do you want it to read like that?
That's what I just
I
read
would
you, 1,
say
2, and 3.
Just number 1
Okay.
would be the most
All right,
narrowly tailored to the case.
okay. Mr. Cruz, any objection to 26231 reading? To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. Any objection to that charge?
No, that's the pattern language, Your Honor.
It is, okay, and we'll cross out 2 and 3. And we're going to cross out the number 1. We're just going to put in, must be done by the defendant. Okay. The state does not have to show that there was an actual break-in to prove burglary.
Hold on, say that. What are we doing now?
So we're
Yeah.
on 26231. So on your copy, it's the middle of page 13.
Mhm.
And what the state has requested is this. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. That's the request.
I understood. So we're taking out 2 and 3.
Yes.
Would the court consider giving the kind of not parenthetical, the example that is given in the pattern? I'm kidding. I'm sorry. So about breaking the plane, football breaking the plane. I'm not requesting that. I'm sorry. I'm just kidding.
I'm not looking at the pattern. I'm looking
Sorry.
at
Sorry.
All right. Any further objection, Mr. Cruz, or any comment?
Not at this moment, Your Honor.
All right, 23010, which is requested by both counsel. And of course, we're going into page 14. It'll be a different page, obviously, when we're finished. Mr. Bolden, any other changes to that request from the state?
No, Your Honor.
All right, Mr. Cruz, your request is 41. Any changes to your request?
No, ma'am.
All right, so it will be given as requested by both parties. We'll go to the next page, towards the bottom of page 14 for us. It's 23210 for Ms. Ellis. This has been requested by both parties. I'll ask Mr. Bolden first, any changes about how you want this charge to be? I mean, this is the pattern, so.
So, I mean, this is where it gets a little confusing because there are the two different aggravated sodomy counts. I don't know if the court's preference would be to charge separately on each of those counts, or if the court thinks giving the definition of the crime once and then kind of incorporating, as alleged in count. Bear with me.
Okay.
As alleged in count 7 to include the sex organ of the accused and the mouth of the victim. And then in count 10, the sex act or sex organ of the accused and the anus of the victim. Or if you just want to define it twice. Does that make sense what I'm trying to get at?
Yes, it does.
I mean, I don't know which way is less confusing. So I think that's why we requested it be given twice. I think that might be the easiest way. So, for state's request 10, for aggravated sodomy as alleged in count 7, the state must prove that the defendant forced, and then I'm looking at the top of page 15, only use mouth. And then give the rest. And then I realize I'm jumping ahead here, but then for state's request 11, that it read for aggravated sodomy as charged in count 10, the state must prove, and then use anus instead of mouth.
Okay, so you're asking some additional language, which is for aggravated sodomy as charged in count 7. That's what you're asking for. Count 7 of the indictment. The state must prove that the defendant, okay, and you want the word mouth, and then you want it read again in the same way as charged in count 10. Of the indictment. State must prove, and then the word anus. Okay. So you're asking then, with those additional words, to read it twice.
Yes, I think my personal opinion is that would be the least confusing way to explain.
Mr. Cruz, I'll hear from you about your thoughts. You had asked also for 23210, you had asked the same, you have the same request, but the state is the only one that asked for it twice, just given the two different counts in the indictment. So thoughts?
I'm fine with it twice.
Okay.
So I don't oppose that. I do have a question for you going back up to
Sure.
rape.
Hang on, just let me make sure Ms. Ellis got it. You got it? Okay. Go ahead.
All right. So, and if it's not appropriate now, I can add.
Oh, go ahead.
With the rape instruction, one of the elements is against her will. We did intend to argue that the state has to show that it's against her will, which I think is appropriate for their burden. I just want to make sure that the court is okay with that, where it doesn't violate anything.
Thank you, Annie, for your kind
Well, that is
words.
the state's burden, and that is the statute.
Yes, I think I understand what Mr. Cruz is asking, and I think that against her will is an element that the state is required to prove beyond a reasonable doubt.
Okay. Are you asking Mr. Cruz? I want to make sure I understand what you're referring to. I mean, I do understand what you're referring to, but in the larger context of this trial and the motions that we've had and things of that nature, are you implying that because that is part of their burden, that you are going to argue anything about consent?
Absolutely not. Now, I will say this, Judge. I may disagree with your rulings, but I respect the court. I always have to respect the court.
And I wasn't insinuating you weren't. I'm just making sure I understand.
But instead of arguing consent, we're just going to put the burden where it belongs, which is on the state. And we are going to argue that they do have to prove that it was against her will without consent.
All right. Thank you. Anything further? Okay.
Understood, Your
All right. And are we then finished with 23210? Let's go back to page.
23210 is aggravated sodomy, and here's the instruction. For aggravated sodomy, the state must prove that the defendant forcibly and against the will of a person engaged in a sexual act involving the sex organs of one of them and the mouth, and in this case, and anus of the other. So they're going to read that instruction twice, once with saying mouth, once with saying anus, and then it says force means acts of physical force, threats of harm, or intimidation. Against the will means without the alleged victim's consent.
Our page 15. 3210. Let's go back to page 15. Anything else from the state on 23210?
No, Your Honor.
All right, Mr. Cruz, are we finished with 23210 or anything else we need to talk about?
Court's indulgence, Your Honor.
Oh, clearly that troll before called themselves court's indulgence because of their hatred for Mr. Cruz. It's wild. People are wild. People are insane. Sharon says this case is a disgrace. She can see it all the way from Canada. Thanks for your super chat. Tammy Fowler, do you think the jury will take it wrong that the defense rested so abruptly? And do you think he was better off doing so? Can you explain better? The defense doesn't have to put on a case at all.
But no, so we're going to do it twice, one for anus, one for oral.
That's correct.
Okay, let's go.
I mean, that's what you said you were fine with.
Correct.
Okay, all right, let's go to the next page then. And to the state's request, 23015, and of course, then 23017. And the state has only requested these.
Yes, Your Honor. And what I would request is the way that what we submitted was a little bit more tailored, and I would just say that sexual battery, aggravated sexual battery not be included, that the state must prove that the alleged victim did not consent to sexual intercourse or aggravated sodomy.
Are you asking for the rest of it to be there too? If you find that the victim was not mentally or physically capable of consenting?
I mean, I don't necessarily know that that is applicable here.
The title of this instruction, 23015, is Sexual Offenses Incapacity to Consent.
Let me ask Mr. Cruz about his position on state's request 12, which is 23015.
Court's indulgence, Your Honor.
Thank you, Kate Willis, for gifting 5 memberships. Love you.
Yeah, I don't believe this applies to the facts of this case. Incapacity to consent. There's no.
Let's back up. I understood Mr. Bolden's comment that you are not asking for that language. Am I right about that? If you find the victim was not mentally or physically capable of consenting, you'd be authorized. Are you asking to take that out in your request? That's what I thought you meant.
Yeah, and
I
agree with the first sentence, but just the following language, it doesn't fit the evidence in this case.
The second sentence that Mr. Cruz doesn't think applies, tell me if you think it applies, is if you find that the victim was not mentally or physically capable of consenting to the sexual act alleged, then you would be authorized to find the defendant guilty of rape or aggravated sodomy.
I mean, I would, yeah, the court doesn't want to
I'm
get,
not sure 230-15 fits this case at all.
and I don't necessarily disagree, Your Honor. I think if the court were to incline not to give that.
I agree. Yeah, I don't think it fits, but I think that first sentence is also in lack of consent.
Sure. Hang on just a minute. All right. Is there any objection to the court not giving 230-15? All right, Mr. Cruz.
No objection to not giving 230-15.
Okay, we're going to cross that out then. And then we're going to go to 230-17.
I would withdraw that.
Can I look at the statute really quick, Your Honor? Not the statute, I'm sorry, the language.
I mean, the state is withdrawing it. If you wanted to request it, we can talk about it, but they're going to withdraw their request. But I'll certainly let you look at the statute and decide what you want to do.
It says the state must, it's other sexual offenses, lack of consent. The state must prove that the alleged victim did not
I
consent to
believe
sodomy.
2030-17 fits the language because of the aggravated sodomy piece. And the particularly the oral charge of aggravated sodomy.
So tell me what you're asking, Mr. Cruz.
I'm asking for 2030-17 to be included in the charges.
Okay. Mr. Bolton, any comment?
I'll leave it up to the court.
Sorry.
Whatever the court thinks is appropriate.
All right, if you have no objection and the defense has asked for it, then I will leave it in. I was going to eliminate it based on our elimination of 230-15, but if you all are basically in agreement, we will keep it in. And I think it just needs to read to the words of aggravated sodomy. I'll just take out the rest of it,
I agree with that.
obviously. Okay, let's go to, did you get that? 230-17? Okay, 220-21. Both parties have requested this. I think number 2 needs to be deadly weapon, would fit the evidence.
Yes, that's the way that it's
All right,
indicted.
220-21 is aggravated assault with a deadly or offensive weapon. For aggravated assault, the state must prove that the defendant assaulted another person. And paragraph number 2 is with a deadly weapon or with an offensive weapon.
yes, it is indicted that way, so we'll. Yes, it is indicted that way, so we'll cross out with an offensive weapon, put in with a deadly weapon. Okay, so with that change, both parties have requested it. Anything else, Mr. Cruz?
I'm matching up the language, Your Honor. Please forgive me.
Okay, that's all right. We'll go to page 17 also. In the top of page 17, we have to finish the pattern. I knew there had to be more to that pattern than just those 2 sentences. All right, when you're finished, go to the top of page 17 to finish discussing charge 220-21.
And so at the top of page 17, Your Honor, I would ask that the sentence beginning with the word however read as follows: the state must prove that the defendant attempted to cause a violent injury to the person, period. And that second parenthetical not be included. I think that would be based on the way the charging language in the indictment. I think that would be the correct way that the correct way for the court to charge the jury based on the way the state has brought that aggravated assault charge.
Okay. Any objection to what Mr. Bolden has just stated, Mr. Cruz?
No objection, Your Honor.
Let's talk about the next line, though, and make sure we're all comfortable with that. An offensive weapon is any object is likely to cause. That's okay. That looks right. Any objection to that last sentence? An offensive weapon.
No, I would ask that not be given. I think that's just probably part of the pattern that comes in if you use the object which when used offensively language. But since here the state has alleged a deadly weapon,
Got it. Yeah.
that I don't think that
Makes sense. Right. Of course. Mr. Cruz, any objection to eliminating that line, an offensive weapon is any object, et cetera, et cetera?
No objection, Your Honor.
Cross that out. Let's go to 2/2023, deadly weapon. And in deciding whether, let's see what this indictment says. A knife. Deciding whether a knife is a deadly weapon. This is 2/2023.
Can we, I believe it's undisputed that the knife was a deadly weapon. If the honorable court wants and if the state is willing to agree to it, I am fine with an instruction if the court wants to tell the jury a knife is a deadly weapon. But I'll leave it up to the state and the honorable court.
You're agreeing to the statement, a knife is a deadly weapon.
Instead of this one, because I don't think either party disputes whether or not the knife was a deadly weapon.
Mr. Bolden, any comment on the offer by the defense?
I mean, I think that's perfectly fair.
Okay, so we'll just say, period, a knife is a deadly weapon.
Correct. I was going to say the parties have stipulated the knife is deadly weapon, but you can say it that way too. I think it gets the same message across, so we're fine with that.
Okay. Say that again. Sorry. Okay, so the next one, 16, okay, 26810, the state has asked for just A1, but the defense has asked for it too. What the defense asked for?
Let me read the statute, Your Honor. I'm trying to find it now.
So here's the defense's part. Okay. Oh, I see. Okay. A1. So there's no pattern. Is there a pattern? Oh, there's no pattern in this. Got it. Okay. I'm sorry. I wasn't following you.
Under the pattern, it just says OCG.
Got it. Okay. I think A1 is the only one that fits. But you let me know, Mr. Cruz, when you're ready.
Okay. I agree with A1, Your Honor.
I'm sorry?
I agree with A1.
Okay. All right. So we will.
I'm sorry, I've gotten lost. Where are we?
We're on 26810 arson, but of course it's just the statute.
Okay.
And the defense agrees that what the state has asked for, A, and then 1 is what's appropriate.
Well, go ahead.
See. Yes, I think we should take out the letter A and the number 1. Sure. Let me just read it again. First one. He or she knowingly damages.
And if I could be heard,
Yes.
I think what the state would ask, is if the pattern only says to look to the statute, and I think that's what I understand, then I think the state's request would be that this charge read, a person commits the offense of arson in the first degree when by means of fire, there's no evidence of explosive here, he knowingly damages any dwelling house of another without his or her consent, period.
I agree with that.
Okay.
No
He,
objection to that.
okay. So he knowingly damages, I'm sorry, he knowingly damages,
And instead of he, can we use the defendant? Oh, I guess it's the same. So,
I think it's probably more appropriate to say he as opposed to defendant. Yeah, I think more general in nature makes more sense. By means of fire, he knowingly damages any dwelling or house of another without
His or her consent,
his or her consent,
period.
period. Okay, and Mr. Cruz, you don't have an objection to that?
I do not.
Okay, so that's how we'll give it. Let's do the next one, arson, presumption of accidental cause, state's request 17, 268-16. Let's see what the. Damage by means of fire is what's in the indictment. Damage by fire, so we're going to cross out the word burned, just for starters. And I think we cross out or as a party to it. There's no evidence about that.
Yes.
Thank you.
All right, Mr. Bolden, anything further we need to change from your request before I ask Mr. Cruz?
No, I think it's an appropriate statement of the law, especially when arson is charged, that they're all presumed accidental. So
Mr. Cruz, any objection to the state's request 17, which it would read, the burden rests upon the state to prove beyond a reasonable doubt that the building described in the indictment was damaged by fire. Number one, the building in the indictment was damaged by fire. 2, the burning was caused by a criminal act. And 3, the accused was the person doing the burning. Any objection to that?
No.
Okay, and then the paragraph below that about the law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire is the result, etc. Any objection to that language?
No, ma'am.
Okay, we'll give it as requested with the changes that we just made. All right, let's look at 24040. State and defense have both requested this one.
Keep going backwards. I got to keep flipping pages. 24040.
We'll put on his person as opposed to his, her.
Knife during
or
commission of a
within arm's reach
crime.
of his person. We can talk about what you all want. All right, let me ask the state first, and then I'll ask the defense what you want. Mr. Bolden, what do you think 24040 should read?
yes, Your Honor, I think that it should read that for the possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with the blade at least 3 inches long.
It was
on
8
his
inches.
person while committing malice murder. Because that's the way that
Okay, that's
it-
what's indicted.
it is indicted. Which is a crime involving another person.
Okay. Which is not which is one of the following, which is a crime against another person.
Yes, Your Honor.
Okay. Mr. Cruz, any comment on how the state has asked for that charge to be given?
None in that manner, Your Honor.
Okay. So it'll read this way. For 24040, it'll read this way. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with a blade at least 3 inches long, 3, on his person, 4, while committing malice murder, a felony, which is a crime against another person.
Yes.
Anything, state satisfied? Is the defense satisfied with that?
Yes, ma'am.
All right, thank you. Let's go then to the next page. We'll cross out the controlled substance, obviously, information at the bottom. 130, 130, both parties have requested this.
Thank you, Amange.
Mr. Bolden, what part of 130, 130 are you asking for? I'm not inclined to put in the 11th Circuit information. I mean, I'm inclined to just stick with the statute. I mean, the statute, the pattern.
It's about
But
expert
I'll hear
witnesses.
from both of you about including the extra language. I think the extra language is taken care of in the pattern.
Yeah, I would agree with the court to give that the first two paragraphs and then not the pattern jury charge from the 11th Circuit. I have no problem with that, Your Honor.
Mr. Cruz?
I believe it's the same. So
Okay. All right, I'll cross out the 11th Circuit opining because it's really taken care of in 130, 130. Okay, 130, 140.
And that instruction on expert witnesses says you are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has specialized training or experience in that field is allowed to state an opinion about the matter, but that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion.
And this was requested by both parties. 130. Okay, 130, 140.
Witness attacked.
And this was requested by both parties.
So can I go through this one with you, Your Honor? Kind of save the court some time. So I don't think anything came out for character and truthfulness. I was on cross, so I didn't bring in any reputation, evidence of opinion or other witnesses regarding a person's character for untruthfulness, bias towards a party. Now, I believe I elicited it, but I will at least say I attempt to elicit it through Detective Ricketts when I asked him specifically, why are you defending Chris Melton? And the purpose of that question was to support that charge, Your Honor.
All right, so let's do this in pieces.
Okay.
You are offering that the component of 130, 140 that applies to character for untruthfulness is not applicable.
Correct. That is not applicable.
Let me ask Mr. Bolden, any comment on that?
I don't believe there's any character for untruthfulness.
I agree with both of you. Okay. Mr. Cruz has made an argument to keep in bias toward a party. We got to read how to do that. In general, do you have a comment on Mr. Cruz's request?
And I'll pull up the statute just in case.
There's nothing about criminal convictions. We're going to get rid of that.
So I guess my position as to bias is I don't think that this is the pattern charge that would relate towards bias in the way that has been shown in this trial. I think it would go to the credibility, the general credibility charge, which I can't even remember at this point if we've discussed or if we will discuss, but that charge has the language about how they may consider their, manner in testifying, the facts about which they testified, and any bias. And I'm paraphrasing because I can't think of it right this second, but that would be.
And I could fully flesh out that argument, Your Honor, in regards to bias. I think that was just one component of it. A bigger piece of it was once the investigation started in regards to Mr. Faust and our examination with Ms. Bigham. And the larger piece of that argument, without going into all the other components, the larger piece of that argument was, if I can remember the statement, and I'll paraphrase the statement, when we had the discussion during the examination regarding the statements made to Chris Melton regarding the actions he should take moving forward. So I do believe we brought in different pieces of evidence through testimony supporting that charge.
Okay.
And the state is the party, just to make it clear,
I
the state
understand
is
what you're
the
saying.
state is. would be
I
the
want to
party.
just see if we've kind of given it in another way.
Sure.
And
The statute. Yeah, go ahead.
what I was referring to is 1.31.10, where it says that credibility of witnesses, the jury may.
I keep doing that to you. All right, hold on. We only have one computer. Let me pull up 131.10 before you get started. And I don't want to lose what Ms. Ellis is doing on the computer.
131.10 is the credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts,
Yes, Your Honor. So that again, like
the facts about which
think
they
we've already gone-
testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Let's hear what Heath says about this.
gone over that particular charge, but if not, I know that we will. But
It's in the beginning of the charge. I have gone over it.
and so the jury will have been charged on, general credibility, and part of that is their interest or lack of interest in the case. So I think that's the type of, I think that's what Mr. Cruz is getting at. I don't think that bias towards a party shown by bad acts, being specific instances of the conduct of the witness, which is in 131.40, is what is contemplated here. So I would ask that it not be given. I know that was part of our requests, but that was anticipating what some of the potential evidence today may have been.
All right, thank you. Mr. Cruz, anything further?
I would just stand by my argument, but I'll leave it to honorable court's discretion.
So I think I agree with the state in terms of this particular pattern, and I don't disagree with your assessment that the issues concerning whether you want to call it bias or interest or lack of interest has been brought up by the evidence. I mean, I think certainly both arguments support that, but we're talking about the pattern, and the pattern, I think it actually would be very confusing to give this charge in the manner in which it is patterned, because it does talk about bias and bad acts, and that doesn't comport with the evidence. So I'm not going to give it in this manner. I do think the issue of whether you call it bias or interest or lack of interest in the case has already been given at the beginning of the charges, and so I'm just not going to give 131.40. I think it would be very confusing. It doesn't really comport with the evidence in the manner the pattern provides.
131.40, witness attacked. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to attack, cast doubt upon, or challenge the credibility or believability of, or cause you to disbelieve any such witness. This would include evidence of character for untruthfulness. She's saying she's not going to give this at all. Felony conviction, bias towards a party. She just said she's not giving this at all, right? Hold on.
Or lack of interest in the case. That doesn't comport with the evidence. So I'm not going to give it in this manner. I do think the issue of whether you call it bias or interest or lack of interest in the case has already been given at the beginning.
It's in a different
The
charge.
charges. And so I'm just not going to give 131.40. I think it would be very confusing. It doesn't really comport with the evidence in the manner the pattern provides. So, all right. So we'll move on to 131.45. And I think we've already talked about this. We already have this in our, we've already given this.
It's about impeachment
Or
of a
wait,
witness.
Let me just make sure. You moved to 131.45. Okay, we're good. All right, let's move on then to 131.47. The defense has requested prior statements.
I don't have any objection. Your Honor.
All right, and let me just read it. Anything further, Mr. Cruz, you want to say in your request?
No, ma'am.
Just as this, all right.
Prior statements, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to
All
statements
right, I thought that,
or testimony of that same witness before the trial started. It is for you to decide whether there is reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. And that goes directly, I think, to Chris Melton. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe.
don't we already give this? I mean, I don't have any problem giving it, but I want to say we already, I feel like this is in our,
It is. It is.
yeah, okay. I'm not going to give it twice.
Thank you, Sunshine Love,
Just
for
find
your
it what page we're on, but
10.
we already give this.
Bottom, well, I'm at the bottom of page 9.
Okay. Yes, it is. It's the bottom of page 9. Yeah. Okay. So we're not going to give it again. We've already given it, but your request is granted. Okay.
Thank you, Jay the Kid, for your 5
131.90.
and thoughts.
Is that not also in the? Okay, that's not typically in there.
Kim the
Give it
Ladybug,
all
thanks
the
for your
time,
5
it's fine,
and your
so thank you.
thoughts.
Okay, 131.90. Both parties have asked for 131.90. Mr. Bolden, anything else?
No, Your Honor.
Okay. About that. Mr. Cruz, 131.90, single witness. Anything else you want to offer with regard to that?
No, ma'am.
This is requested it.
No, ma'am.
I will give it. 132.16, statement of defendant. You both have requested it.
Statement
But
of
I think
defendant.
At least the while in custody is appropriate.
A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of his or her constitutional rights.
Was it shown that he was in custody in that video?
Yes.
Oh yeah, he was cuffed. Are you going to act right if I take these cuffs off?
The evidence was presented that they asked to remove the handcuffs, and that was shown. Yeah.
Kim says this is a miscarriage of justice. The court's trying to convict an innocent man and allowing the guilty man to go free due to systemic failure. Thank you, Kim, for your thoughts and your 5.
What's 134? We're going to pull up 134. You both have asked for this. Mr. Golden, anything further you want to ask for?
No, Your Honor. I think that both of the parentheticals would be applicable here.
So how are you asking it for it to be read? Obviously, we're going to get rid of OCGA 24.
Sure. Just exactly as it reads.
Statement was voluntary, comma, if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. Is that correct?
Yes.
Without the parentheses.
Yes.
All right, Mr. Cruz?
I'm reading it, Turner.
Okay.
1 second.
I just asked both of them how long.
Karen, thanks for your super chat. She says, I can't be the only one thinking that the state and GBI took Faust DNA, put it on a swab, and that's the oral swab that somehow magically has only Faust DNA and not Tara's. You are not the only one. Let Karen know what you think of
okay.
that comment. Thank you for your 10.
All right, no objection. Obviously, we're removing the limiting instruction conditional admissibility language.
I was just reading that 134.50. I don't think it applies, but I mean, I'll hear from you if you think otherwise.
No, it doesn't apply to that.
Okay, so are you satisfied with the way you both have asked for 132.16? Are you satisfied with how it's written there? without the parentheses.
Correct.
Okay, we will give it. 132.17. Both parties have asked for it.
That is 132.17, voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of evidence, use of violence, fear or injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of free will and not under compulsion or any necessity imposed by others. Interesting that the prosecution.
I'm going to, as you go through 132.17, next page 23, the top, I'm going to get rid of the statement in determining voluntariness because we basically said that twice, and I don't want it to be confusing. I don't think we need that, but I'll hear from both of you. Mr. Bolden, do you have any objection to just 132.17 as
No, Your Honor.
on 22? Okay, Mr. Cruz?
I'm reading it, Your Honor.
Interesting to me that the prosecution never called that jailhouse snitch that they wanted to call.
This is a request by both of you.
Oh, here comes I drop bailiff again.
Okay, you're saying on page 23 at the top, you were taking out.
Yeah, it's been said several times, and I just think it's.
Okay. But otherwise, I have no objections to the vote.
Okay. All right, let's do 132.18, next page, page 23. The defense has requested this one.
Circumstances of the statements.
And Your Honor,
Illegal detention.
understanding that Mr. Cruz and I might disagree over the legality of the detention based on our motions back in the fall. I would object to this. I don't think this is the type of situation that charge is designed for. If the court were to give it, I would ask that it read as follows. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made, but not give what's in the parenthetical.
You offered this.
I just double check it, please, Your Honor. I would request it, but I would leave it to the honorable court's discretion.
I don't think it fits the evidence. And, I think it would be confusing. There's been no evidence concerning this particular kind of a charge. So I'm not going to give that charge. 132.19, burden of proof as to voluntariness. Both parties have requested it.
I don't have anything to add.
All right,
Your Honor.
anything further, Mr. Cruz?
Just checking the language, Your Honor.
All right.
And I know I request, I just always double check the,
I know I'm going fast. I want
Ema.
to get a break before 2:30. So
Thanks for your 5. Alternate jurors in Georgia are decided before the trial starts. They already know that they are
all
alternate.
right, let's go to the next one.
Great question.
Constitutional rights. Both parties have requested that. We'll cross out her just for starters. Word her.
So it's to do with the defendant being Mirandized before he gave his statement in the
Cross out she.
police department. Thank you, Cupcakes for Justice, for your 5 and for your wishes, your birthday wishes. Love you with all my heart. Say what now? Said, I think Mr. Cruz made the right decision. He wasn't allowed any room to argue and just wants to get out of this judge's courtroom. Insanity. Thanks for your 5.
We're going to want, well, first of all, any comments on 132.21?
No, Your Honor.
All right, what about, you both requested top of 24 where it says anything, and I'll cross out she, he said, wrote, signed.
I mean, I think if I remember correctly, when Agent Bigham read Mr. Faust's rights, she used the word said. And so I don't think wrote or signed are necessarily applicable.
I have no objections to the language, Your Honor.
We'll just cross out the words wrote and signed, and obviously the word she. Okay. The next one, 13240, the defense has asked for this.
I think that's a.
We've given that in 13219.
We did give that in 132.19?
Well, it's basically the same thing.
I think 132.19 is specifically to voluntariness. 132.40 is in regards to just the Miranda rights as a whole. Because I think with waiving a right is intelligently, voluntarily, and a little missing one. I want to say freely, but I don't think that's appropriate.
I would say that the state does not have an objection to 13240.
All right. I mean, it is a bit redundant, was really my hesitation. And this is why. 132.19 and 132.21 deal with all of the things that are in 132.40. But
Whatever the honorable court's rule.
well, you've requested it. And even though it's redundant, that was really only my concern. But if the state is not objecting, I'm not going to make a big deal about the redundancy. It's not overwhelming, but that was only my concern. Not that it isn't the proper law. So we'll give it. 132.50, both parties have asked for this.
Thanks, Johnny. New York, for your thoughts.
And so, yes, my only comment, Your Honor, is to just get rid of the parentheticals at the end.
Conditions precedent to consideration of statement of the defendant.
I have no objection to that, Your Honor. And 132.70, I would ask to be removed. I don't know how.
You're going to withdraw that?
I am.
Okay. Okay. So I guess my only concern, even though you both have asked for 132.50, is, again, the issue of redundancy. I mean, we're sort of saying it over and over again, and in just slightly different ways. And so that's my only concern. But I'll hear from the state first and then Mr. Cruz about that issue.
I mean, I would agree with the court that it is redundant. I just know that in every trial that I can recall in which a defendant's statement was played, I think there is just that extra caution to make sure a jury, and so I don't disagree with the court's the court's concerns about it being redundant, but given that it is all part of the pattern, I don't object.
All right, Mr. Cruz?
I would agree with the state.
All right, I'll give it. Let's go then to 25. We've crossed out 132.70. We're on 134, limiting instructions. I don't think we had any of those.
Well,
Did we?
there could have been that 413 evidence, Your Honor. The state opted not to introduce that evidence, so I don't think it's applicable in this case. With it.
I think we do have it in regards to Ms. Sims. You told me we could take it up at the charge conference in regards to her statement that what she tested was sperm, and we went through cross-examination, and then she said, well, we didn't, I didn't test it for sperm. I didn't know about the report that it was sperm. At the time you told me to address it now. I would ask for a limiting instruction to the jury in regards to that statement that she made. And if the court is willing to give that limited instruction, I would ask for this pattern charge. But if the court is not inclined to give a limiting instruction, obviously this would not apply.
So describe for me, Mr. Cruz, I don't remember the conversation, but describe for me why you think you can certainly talk about the limits of her testimony if you want to do that, certainly, regardless of whether she's tendered as an expert. I mean, you can certainly go there if you want to. But in terms of the charge, tell me how it applies to the request for.
Sure. The charge only applies if the honorable court is inclined to give a limiting instruction in regards to the testimony. If the honorable court is not inclined to give a limiting instruction in regards to the testimony, the charge does not, it's inapplicable.
Sure, but I guess
applicable to this
what
case.
limiting instruction would you be referring to? I guess that's what I'm
The
asking.
only thing I would ask, because there is no evidence of semen in this case. Outside of Detective Bigham
Right.
saying that Chris Melton's semen was found, every other test, everything looked at in the testimony, no testimony came out in this case that semen was involved. When Ms. Sims, who just did the differential extraction, she started saying, and I may say the wrong, I think she said either semen or sperm, but she said one of the two. She started using that language. And that's when I objected and discussed saying with the Honorable Court. I would just ask the Honorable Court to give a limiting instruction to disregard. And she corrected it after I made the objection. She stopped referring to it as that. But just to give the jury an instruction to disregard Ms. Sims' characterization as the DNA evidence as sperm.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, would you like to respond?
Yeah, yes, Your Honor. I don't believe that's what this pattern jury instruction is designed to address. The issue with Ms. Sims the other day, I don't want to, no need to get back into the evidence, but like, I think
Or lack
if
thereof.
Mr. Cruz had requested a limiting instruction at that time, I could see it. But this is designed for extrinsic acts and the court telling them that they can only consider that for a specific purpose. That's where it falls in the pattern. It's not applicable.
I agree. I agree with you there. I agree with him in that position. Looking at
Gypsy Soul says they feel like the state witness be the kind to send an e-swab and compare it with that CODIS
Okay,
instead of compare it
so-
with the sample from Tara, and that's why Tara's
Before we
DNA
get to
wasn't
the next
present.
page,
Thanks for your 10.
both parties are agreeing that 134 does not apply right now. We're not going to give 134.
That I
You agree with that? Is
It's
that right?
limiting instructions, purpose
purposes
parties
or against some
counts.
parties, not others, or for some counts and not others. Such evidence may be considered by the jury for the sole issue of purpose against. Right. It wouldn't apply to what I'm asking for.
Okay.
But I would still ask for that limited instruction if the Honorable Court is inclined, but this wouldn't apply. I
Okay.
agree with the state.
Okay, so I'm going to get rid of 134. I'm going to say with regard to the limiting instruction, based on how both parties have described the moment, particularly Mr. Cruz, your comment that it is the characterization of the evidence. I think if the court got involved at this point with doing what you're requesting, the court would be inserting itself into characterizing the evidence, which would be improper. So you can certainly argue and bring up however you choose to the jury. It's not limiting for you. But I think in terms of the court charging the jury, it would be improperly inserting the court's opinion, which it doesn't have, of course, but sort of suggesting the court had an opinion on the characterization of the evidence, and that's not proper. I'm just going to do it in that way. But I'm not limiting you in describing however you choose to how the evidence played out. So I'm not going to give 134. Both parties have agreed to that. Let's talk about 134.10, which does require 134.
I would withdraw that, Your Honor.
Okay, I don't think it fits the evidence. Okay, all right. So the state is withdrawing that next one. All right. So now we're going to the next page, the middle of the next page, which is 134.20. And this was defense request. So I'll ask Mr. Bolden first. Any comment on 134.20?
I don't think there's any of that in the evidence in this trial. I'd ask that it not be given.
All right, Mr.
I could withdraw it. I withdraw the
All
request.
right, we're going to withdraw 134.20. 134.30 needs to be withdrawn.
Yes, Your Honor. They will withdraw that.
All right,
134.30 was about prior convictions, and no prior convictions got in, so it's good. That's a good ruling. Or he withdrew it.
and the top of 28, of course, as well, is withdrawn. 135.30. And this is the state's request.
It's about DNA.
I would just ask that it be given as charged.
Do you want the words "or believability," which are in parentheses, to also be included?
Yes. Oh, I'm sorry.
I
You can offer your opinion. Go ahead.
Yes.
Okay. All right.
I don't have any issue with that.
Mr. Cruz, do you have any objection to how the state has requested 37?
I'm reading this statute.
Okay.
I mean,
All
the pattern charge now, Your Honor.
Evidence relating to DNA
I'm gonna,
comparison has
get
been
rid of the words
admitted
admissibility may be ruled on.
for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case.
Et cetera, because that's not. Okay. Disability may be ruled on, et cetera, because that's not. Okay. Just that little part.
Well, I think this is the issue here because I'm just now seeing this wasn't DNA comparison. This was actually, and maybe I'm reading too deeply into it. From what I understand from true allele and DNA comparison, one type is where a human does it and they compare it. And correct me if I say anything wrong. True allele is like a computer program that just says, hey, this is the likelihood ratio that this DNA or this pattern of DNA compared to this person would show. I'm trying to use correct language. Would pop up among a random member of the population, if that makes sense. So, but we could give it. I have no objection to it.
All right. I think it fits the evidence, so I will give it as charged then. All right, the next one is defense's request, 14010, definition of crime. That should have been given earlier.
It was.
Okay, so I'm not gonna do twice, but I'll grant your request, but it's already been given. 14015, state's request.
And Your Honor, the only thing that pops into my head with this request is the burglary count where we've alleged enter and remain within the dwelling house of another.
Okay.
I know sometimes it's almost maybe it's almost better to wait and see if they have a question about like the and or conjunctive versus disjunctive. And so I would be okay with the court not giving it, withdrawing that request at this time. But again, that I know that does happen from time to time, and then we have to give additional instructions. So that I think that was the rationale behind that.
Okay, so you're going to withdraw it, but that does come up from time to time. Yeah.
Well, I would object to the instruction as a whole, because from what I understand from the indictment, everything is charged straightforward. And with the entering and remaining inside, I believe that's the state's theory of the case, that not only did Mr. Faust enter, but for a period of time, he remained inside and did these acts.
Okay. Any response?
Yeah, I mean, it's the state charges in the conjunctive can prove in the disjunctive, and I think that's very well established. But I think given all the other confusing aspects of the law, I don't necessarily want to interject another one unless they specifically ask. So I guess that's kind of the dueling concerns that I have.
Well, I think it's probably best to address that issue this way, to not give it as charged. I do think it is probably confusing, and I agree with you, Mr. Cruz, in the concern about giving 14015, but it is an accurate statement of the law. And so I will just say this: if it comes up in a question, we're going to have to talk about how the court needs to respond to the question. And it may be that the court has to respond to the question this way, because this is the law, but I'm not going to give it as a charge. All right. 14112 is requested by the state.
I would withdraw that, Your Honor.
So that is withdrawn. 15010, statute of limitations. There hasn't been any evidence about statute of limitations.
Well, and again, this came up when we were talking about CODIS the other day, Your Honor. So on some of the counts would have statute of limitations issues, but that statute was told based on the date that law enforcement received the CODIS hit, and that is alleged in the indictment in multiple counts. I believe beginning with count 6.
Okay, all right.
Own. And so, I think that's a material element that the state does have to prove. Now, the question is, I don't know what the statute is on some of these crimes, or at least what it would have been.
It's 4 years for felonies. I think murder, and I could be wrong on the murder one, so double check. I think it's 7 years if the person is known. If the person is unknown, it's an unlimited statute of limitation.
Well, and that's not, there's no tolling language alleged in the counts alleging murder or felony murder. It's the predicates.
So for the underlying felonies, 4 years is what I believe the window would be. But double check me. I'm never too certain.
I guess my concern, I understand exactly what you're saying. I think we have to figure out how to do this right, because there has been no discussion at all, and no evidence, I should say, no evidence at all about the phrase statute of limitations. And so this would be the first time, right, the jury would be hearing that. And so,
I think it applies to the indictment, because they will have the indictment and will have that language on it. And the state, that is something the state does have to, oh crap, we didn't get into that intro.
I guess in the problem is the language of this indictment doesn't talk about the statute of limitations in that sense. It talks about it in a different way. Perpetrator,
Yes.
the crime alleged was unknown to the state of Georgia. So, I understand exactly what you're saying. I just think we have to tailor this so it makes sense.
Thank you, Norman, for your 10. A Bowdoin defense is
Maybe we do it this way.
specific to Massachusetts. They don't have a Bowdoin. They don't have Bowdoin in Georgia. We looked it up earlier in the stream. Thanks for your 10.
I don't know.
Can I have a second, John?
Of course.
I may have a motion. I just want to look up something really quickly.
Autistic Grandma, thanks for this info, but that's not with regard to this case, correct? That this judge gave an excellent interview. I don't think it has anything to do with this case specifically, does it? That was on a different case, yeah? Thanks for your deuce. We're a little tiny bit behind.
Okay.
And then
Prosecution
the law prosecute. Then I
charges. The accused is on. So, Mr. Bolden, I would imagine on page 30, you would want me to put all the charges. The accused is on trial for the offenses of, and list all the charges, right?
yes.
Okay.
And then I think it would, what I would then ask under Georgia law, prosecution for the offenses of,
And then list them all. Okay.
and then,
Prosecutions for these offenses.
well, so this is confusing. I agree with the court. So I would say that laws of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for, and I would ask that the court read all of them, and then say that under Georgia law, prosecution for the offenses of, and then start with count 6 burglary, count 7 aggravated sodomy, count 8 rape, count 9 aggravated assault, count 10 aggravated sodomy, count 11 arson, count 12 possession of a knife during the commission of a felony. I don't necessarily know that you have, I'm asking the court to read those count numbers, but say that under Georgia law, prosecution for the offenses of, and then list those 6 or 7 offenses. Those offenses must begin within 4 years after the offense has been committed. And then I think maybe the court could see where I'm going from there as to how to tailor it on 150.11 and 150.12.
Right, and I'll hear from you, Mr. Cruz, in just a minute. I'm trying to figure out how to do this. So you go from under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12 within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that B, the person committing the crime was unknown.
Exactly.
Get rid of everything else. And then we can talk about whether the language, if you find from the evidence that this case is not filed, blah, 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 we can talk about where that goes. When the statute of limitations is, when the statute of limitations is raised. I think we just say the burden is on the state. Get rid of when the statute of limitations is raised, because it hasn't been raised.
No, and I think of it as like a venue issue. You know, the court's always going to charge on venue as a jurisdictional fact. I think that the statute of limitations is a jurisdictional fact as well. And so that's why I think it's, even though it hasn't been raised, that it's important to put that out there.
What is your position on the language? If you find from the evidence that the indictment or accusation in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit the defendant.
So I don't think that that is tailored to this case. I would say that, again, going back to 150.10, under Georgia law, prosecution for the offenses of, listing those offenses, must begin within 4 years after the offense has been committed. I would ask the court not to give that last sentence. And then say,
of course, you don't want that admitted.
In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown. And I think that that would be tailored to the case and to the way that the indictment, has been drafted.
All right. Mr. Cruz, sir, any comment on what the state is asking for?
Where's that language, Your Honor? I'm looking for the language that you mentioned.
Okay, so we jumped around a bit. Let's go to page on in your documents.
This is a long charge conference.
Bottom of page 29 is the state's request 43, which is 150.10.
150.
And this is what the state is offering. Now I'm at the top of page 30. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of, and it would list 1 through 12. Next sentence. Under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12, and of course the court would read those offenses, must begin within 4 years after the offense has been committed. And skip down. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that the person committing the crime was unknown.
Question. I believe did you say the paragraph where it says if you find from the evidence that the indictment or accusation in this case was not filed within blank number of years at the?
Yes, the state has asked to eliminate those sentences. And I think that's proper to eliminate that sentence.
The only thing I would say is because the state has
The jury was told to come back at 2:30.
that burden. I think the follow-up sentence, the person committing the crime was unknown. We're not going to argue statute of limitations, but in regards to the jury's understanding of the case and having the indictment, I would just ask for it to be present. But I don't think that's anything we're going to argue. But I think it kind of flows into 150.11b.
Okay. I'm not going to give that portion of it. I do think it's confusing because on the one hand, we're talking about the sort of the tolling and then reinserting back in language. Well, if you find it hasn't been accused or indicted within a certain period, I think it's very confusing. So I'm not going to give it. But let me ask you, Mr. Cruz, before we get to kind of the rest of it, top of page 31, the state requested 45. I have eliminated the front part of that where it says when statute of limitations is raised and just put in there, the burden is on the state to prove that the offense occurred within the statute of limitations or occurred within an exception beyond a reasonable doubt.
I would ask for the statutory language, Your Honor. So I would object to that portion being removed. Not statutory, I'm sorry, the pattern language.
Okay, let me look at the pattern. 112, okay. That is the pattern? Okay.
We're a little bit behind, but not much.
Has not been raised that because the statute of limitations has not been raised,
Right.
that telling them that it has is going to be confusing. So I agree with the court to just start that charge 150.12 with the word the burden is on the state to prove that this offense.
I think that makes sense. I think we need to start with the burden is on the state. That is the pattern with the exception of when statute of limitations is raised. All right, the next one is grave suspicion. Does the defense, defense asked, I don't know if the defense asked for that or not. I always have it in there.
I did ask for that, but I don't see it on.
It's right below, it's next. Yeah, it doesn't have a title. Where it says facts and
Understood.
circumstances. Yes.
Not a house defendant says maybe the instructions wouldn't be confusing if they were in layman's English.
So
Mr.
do you
5.
see 150.12 on page 31?
I do.
Okay, right below the very first.
I see it.
We just didn't label it. Mr. Bolden, any objection to the court giving grave suspicion?
I mean, I always do. I would object if the court were inclined to give it. I would ask that it go up with all the other information about reasonable doubt. The state's position is that, there are cases that hold that it is unnecessary, that it is adequately covered by the court's charge on reasonable doubt, burden of proof, things like that. So I would object.
Okay.
But if the court were to give it, again, I would ask that it be related to those patterns.
I think that makes sense. I've always felt that we've always had it at the end and it feels a little bit weird reading it out of context. So I am going to give it. I'm going to grant your request, Mr. Cruz, and we'll put it in where all the other issues of the state's burden, the burden of proof is, I should say. We'll put it there. All right. The rest of this is, I'll let you all look at it, but page 31, and I'm rushing through because I want to give you all a little bit of a break. 31, 32, and 33 are basically the new instructions. They're not really new, that the Council of Superior Court Judges has issued about how to talk about the indictment and going in the jury room and things of that nature. This does not vary, I would say, amongst the superior courts. This is the standard appropriate comments the court makes about these things. And so I'll ask you to look at them, but I always give these, every superior court gives these. This is the modern new version. The newest version is really at the bottom of 32, where it says these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. That actually was added in by the council. And so unless there's any comments you all want to make on those, we're going to keep those in there.
The only thing I would say, and On 31, where it says as to the 12 counts of this indictment,
Okay.
if the court might consider putting as to each of the 12 counts of this indictment, and that's really splitting hairs. I realize that, but just the idea that it's not.
I mean, I think that makes sense.
Thank you.
Any comment on that, Mr. Cruz?
No, ma'am.
Okay. All right. And unless you all have anything further you want to add for the deliberation charge, again, I don't really want to add anything to the deliberation charge. I think and the Supreme Court, of course, approves the charges that are changed. I think they've come up with the language that is best. I don't really want to add or subtract the Supreme Court's direction about how to speak to the jury about deliberations. I think it needs to be uniform across the board. And so unless there's something we need to talk about, I want to keep it as is. Anything else?
No, ma'am.
Okay. All right. We'll be in recess till 2:30. We'll see you all then. We're going to get this written up. Thank you.
That's it? Until 2:30? It's
we're gonna email
2:20.
it.
It's 2:20 right now. And we're only a couple minutes behind. I mean, I don't know if she's going to start closings at 2:30. She told the jury to come back at 2:30. So remember how long the openings were? You think she's really going to be back at 2:30? Trial Addict says, here since can't read, but finally made it official. Love you. Oh, I love you even more. Thank you so much. 302 Girl says, why didn't they ever get Melton's laptop since Tara's was missing and most likely used to communicate with Chris? He had one for school, right? Well, he wasn't in school at the time of the murder. He was a plumber or trying to be a plumber, or maybe was a plumber and maybe worked for Nash Plumbing. I don't know if they ever got his laptop. I don't know that that was ever brought up. That is a great question. Thanks for your super chat. Gussie says, my sister is a SANE nurse in Connecticut. She said, there is only one swab for oral collection in the kit. I don't know if kits are different in different states or in 2001. A SANE nurse usually is doing it on a victim who is alive, correct? So these swabs were taken by the medical examiner, as I recall, right? All right, here's what we are going to do. I have made an executive decision to, let's see. Tammy says, do you think the jury will take it wrong that the defense rested so abruptly? And do you think he was better off doing so? Can you explain better? No, they're not. They're going to be instructed that the defense is not required to put on a case at all. I cannot hypothesize about how certain jurors might feel about that or not feel about that. Do I think he was better off not putting on a case? I may have liked to have seen a DNA expert, but Ali Mata was in here before. She is a criminal defense attorney, and she says, she said not putting in a defense after you establish you had witnesses to call and a defense to present can support an appellate claim that the court denied his right to a fair trial and ability to present a defense. But she says, but not calling a DNA expert, in my opinion, is indefensible. Should have put on a defense expert. I mean, I felt like that was the only thing that really needed explaining. And so I think it is a strategy decision. Here's what I'm going to do. I'm going to teleport you over to a new stream. We're going to start a new stream for closings so that will be a clean, separate, hold please. Separate stream, because some people said they were getting commercials. I'm going to see if I can correct that. And so I think that is going to solve the issue. You buckle up your seatbelts, and what I'm going to do is teleport you over to the next stream. So just hold please for 1 second, and everyone can go grab a drink, and we'll come back at 2:30. If the court is delayed, I may just give us a couple of more minutes. so that everyone can go grab a drink. Where did this go? And why is it not here? Please. Hold on for 1 sec. All right, so everyone go hydrate. Come on right back. You should be automatically teleported. Let me just make sure I set that up. And then we can have closings as a separate stream, and we can hold on, is this the right one? Yeah. All right, everyone buckle your seatbelts. Go on, get yourself a drink, get yourself some hydration. You have a few moments. I doubt she's coming right back at 2:30. I highly doubt that. All right. That's what we're going to do. I've decided. Thank you, moderators. We're going to see you over there in a second or two. And stay cool, stay kind, stay classy, and all the rest. Okay? Beverages will be provided in the teleport at your own expense. You can go grab yours. Go grab them right now. Buckle up, buttercups. We're getting over there. Peace. Enjoy your short break.